May I please, ma'am? My lord, I beg to mention item number 53, my lord.
Yes.
My lord, I have cross-checked the reports, my lord. I am yet to receive the paper book, my lord.
Okay, well, this is in order. But are you here or going?
I'm here, my lord. But then it's a simple. I am yet to receive the paper book, my lord. It is already
Not yet received.
not yet received.
Otherwise, paper book is ready.
Yes, my lord. Yes, my lord. There is only issue.
Then in that case, if the paper book is ready, after you receive, then this can be for hearing.
Yes, my lord. Yes.
Who is for the petitioner? It's a criminal petition.
Yes, my lord.
In the criminal petition, paper book prepared.
Yes, ma'am. They have already received, my lord. I'm for the state respondent, my lord.
Okay, you are for petitioner. You are Mr.
Yes.
S. Sriram, Lana Council for the petitioner is present. You have received the paper book. Okay, Mr. O. Pada, Lana Council for the respondent. Sorry, Lana Special PP. Standing PP.
Yes, my lord.
SI or standing council. Here, what do we?
Criminal case. Special people.
So here, special PP.
Yes, my lord.
Okay. Then it's not SIC,
ACB.
SCB. Some is that he is yet to receive the paper book. The registry shall furnish a copy of the paper book to the landed special PP, SCB. And who else? Party? Petitioner and who else is the respondent? Respondent only
Respondent.
special PP or any other?
No, my lord. Only
Okay.
the state respondents, my lord.
Paper book, whether it is ready,
Yes, my lord. I've just put.
the copy is available.
Yes, my lord.
Okay. After start with Kama, the matter may be fixed for hearing.
My lord.
After
After puja break, my lord.
after puja vacation. Okay. The interim order passed earlier till the next date of listing. Okay.
My lord, I further beg to mention item 50, my lord.
50.
Yes, my lord.
Yes.
My lord, here Mr. Picha was appearing, my lord.
Okay.
So he is unwell due to, or he is on medication, taking rest because of the ailment. So may I humbly pray, my lord, this may be fixed after the puja break, my lord.
Okay. On the prayer of the parties, let this matter be listed after entering puja vacation.
My lord.
Okay.
Obliged, ma'am.
My lordship, I beg to mention item number 60. On behalf of
Item?
senior, on behalf of
Oh.
a senior advocate,
Criminal case.
he is out of station. So he instruct me take adjournment for today.
Mr.
B. Sibo.
Lana Council submits that. Conducting council, Mr. Mook Patni, Lana Senior Council for the appellant. He is out of station, therefore pray for adjournment of the matter. For
For 3 weeks.
3 weeks. Have you informed the other side?
Yes,
There
lordship.
is also private respondent? Okay. The prayer so made has not been objected with by the Lana Council for the respondent. Accordingly, the prayer is allowed. It is matter after 3 weeks. Okay.
May it please, Lordship. Lordship, I beg to mention item number 4 and 5 on behalf of K. Sakshen. I've taken the consent from Tony Pertin. The matter may be posted for this coming Tuesday, Lordship, that is 23rd of September.
You are on behalf of
K. Saksena.
Archana is for the, okay.
In item number 4, we are the respondent.
Item 4
Yes.
for respondent and
Yes,
item 5 for.
5, we are the petitioner.
You have taken consent for the.
Yes.
Uh,
Yes, Lordship.
Okay, you are Miss
M. Bori.
Lana Council. Your name is not there,
No, Lordship.
appearing on behalf of Mr. Kamal Saxena, Lana Council for the petitioner in item 5 and respondent in item 4 with the consent of the land council of the other side. Praised for listing this matter on
23rd of this month.
23rd. The prayer will is according on 23rd. Okay.
Outlook, Your Lordship.
Mayor, Your Lordship.
Hmm.
I would like to mention item numbers. Of
Item?
Aringo, item 7.
Okay.
On behalf of Aringo, I have also taken consent from the other parties. Kindly, this matter may be listed after 2 weeks.
Your name is not there.
Yeah, no.
Mr.
On behalf of Aringo,
You are Mr.
T. Tolo.
Solo, land council. Appearing on behalf of Mr. R. Ingo, land council for the petitioner with the consent of the land. Praise for adjournment of the matter. for
Yes,
2 weeks.
Lordship.
The prayer is allowed. This matter after 2 weeks.
Much obliged.
Item number 1.
Yes.
My lord, this criminal petition is filed for causing of executive orders issued by the
Yes.
SDO Papampare, Duimu, on dated 31/7/2025.
Executive
On
magistrate.
the ground that it has been issued without authority and without jurisdiction of the court. Because the executive order was issued for the issued under 164 164
What
Bharatiya
this- what-
Nagarik
What
Suraksha
is this order for?
This was regarding the petitioner has a lane at Lake Village that is within capital region. But Duimu, the authority, executive authority has issued order under 164. That is my lord at page 60, page number 60.
What is it for?
That is for the status, for maintaining of status quo in the interest of peace and tranquility.
He has received complaint.
Yes, he has received complaint. On the basis of a complaint, the executive minister Duimok has issued this order, which is annexed in.
What is wrong in it?
My lord, my submission is that the executive authority of Duimu has no jurisdiction within the capital region, and capital region has their own authority. And
Who has the authority according to you?
it is the capital region, SDO Duimu, SDO capital region is the authority, because it comes within the capital region, and all the petitioners, all the LPC is issued by the capital region.
Have you filed objection there?
I have intimated to the authority that an application dated. After receiving this order, I have intimated before the authority on dated that is in page 65, 31/7/2025.
Hmm.
Complaining, intimating that the Duimuk authority has the executive authority has no authority, because this area jurisdiction is different. So very other maybe
No,
cancelled, but
if-
it has been unheard.
If the executive magistrate doesn't have the jurisdiction or his jurisdiction doesn't cover this area,
Yes,
then
my lord.
how would he issue notice or issue this order? What about this breach of this and then submit report? Whether the report was to be submitted within 31st July, whether the report was submitted? Who was directed to submit report?
It is the authority of the Duimuk, the executive authority, executive magistrate of the Duimuk has
Okay,
issued.
whether the.
Because so the petitioner, all the lands belong to the petitioner lies within the jurisdiction of the capital region, and he has no
That is right.
authority to issue such orders to the petitioner. It is for the only capital executive magistrate of capital region to issue such orders if required. And the petitioner has all the valid LPC.
The disputed plot land located at UPA 1, which is likely to go to, it's UPA 1 only.
Yes.
UPA 1 is.
That is the thing. UPA 1, he has the jurisdiction, but we don't have any land in the UPA 1. We have a land at
Then
Lehi.
why you are worrying?
No, my land has been, the police authority has came and stopped my work. And I have intimated that the police has said, no,
You file FIR against police if they doesn't have a authority or jurisdiction.
and by name,
Why should they help you? Because this is separate land.
yes,
If the
my lord,
direction is for the separate land, why should police?
separate
why would
separate land,
police come to you?
separate jurisdiction.
Then you lodge complaint against police.
My lord, it was,
Because this according to you is not connected to your land.
my lord,
isn't
the police authority has done on the basis of the order passed by the executive order,
But this is just
executive
UPA 1.
authorities.
They knows their own jurisdiction, police and executive magistrate. Who is to decide the jurisdiction, territorial jurisdiction? Who should decide?
As per my, executive authority should know their
Yeah.
own jurisdiction.
Hmm?
Even the police has no jurisdiction to enter in my land because it lies within the capital.
That is why I'm saying, you lodge complaint against the police.
But as per the police has acted as per the order issued by the executive magistrate.
That
It
is
was-
why I'm saying,
Direction has been given to the IO.
executive magistrate has issued this for maintaining of the status quo order, the land which is located at UPA 1. According to according to you, your land is not located at UPA 1. Now the police has come to stop your what construction or what? Then you lodge complaint against the police. They are illegal. You don't have to worry about the executive magistrate order. Why should we interfere with the status quo order passed for the lane at UPA 1, and your lane is not at UPA 1? Why
Yes,
should
yes,
you worry?
that is at Likhi.
You should neglect it, ignore it.
The police authority has been directed by the executive authority, executive magistrate.
Police,
Police authority has been directed by the executive magistrate
executive
to interfere,
magistrate.
and
See,
stop
the
my
direction of the executive magistrate, the lane at UPA 1 only.
year.
And according to you, your lane is not at UPA 1.
Yes,
Why should you worry? If anyone comes, police or whosoever comes, on the basis of this order, because your lane is not there, you can lodge complaint against the person who stops you, who comes you, who trespass your lane. Write complaint against the police.
my lord, that is legal precedence, but the general public, they fear about the police and that they
You are not the general public.
general public, that is why we fear about the police. Since they have stopped.
Whosoever may be,
Hmm.
cannot come illegally, cannot stop you. Even if they say also, since they doesn't have any authority, power and authority, you should not stop. If they forcefully do, then you lodge complaint.
That is why we approach for the question of the
how-
executive orders.
How would we recognize? This land falls under the
My lord, I
UPA 1,
have,
UPA 2.
no, my
How
lord,
would we
my lord,
identify?
my lane, all the records of my lane has been placed
That is why
Hmm.
your land is not connected with the order passed by the executive magistrate.
Yes.
You don't have to worry.
But specifically by name, in page number 63, my lord,
Tell the magistrate,
that
tell
is,
the magistrate, there is a difficulties, there is identity.
where it is further land that Sri Gyamar Thakkar Bharat has sub legal notice, even sought intervention of the Sri Navam Gai GB.
You inform the
UPR to
executive magistrate then. You
No.
inform the executive magistrate that this doesn't come under your jurisdiction.
My lord, I have already intimated an application.
What
Before
order was passed in that?
no compliance has been made. That is, reflected in page number 65. No compliance has been made. I have already written on receiving of the such order. I have written to the executive magistrate Dwimukh, intimating that that my land is not within the jurisdiction of your. That is in page number 65. 64 and 65 is the type copy. And it has been not complied. That is why we are compelled to come before the Honorable Court. We have already intimated regarding the jurisdiction and with the authority on 31st/7/2025. But that has not complied. With due respect and humble submission, it is to bring to your notice the location of the plot of land which Gyamar Thakkar has informed your office in his complaint is not under UPR 1 village, which falls under ICR administration. That is my area. Moreover, Gyamar Thakkar has moved Honorable Court of Civil Judge Senior Division for injunction on several occasions has been repeatedly rejected by the Honorable Court. Therefore, under above circumstances, it is requested to your good office that necessary action may be taken, for misleading the government office, and the police may also be directed to take coercive step in this regards. This was the complaint made by the petitioner.
By this order,
Hmm.
the report was to be submitted within 31st July. What was the report? What was the report on that? Do you have the copy?
No, we don't have the copies. They have some land disputes within UPR 1 and UPR 2, and that is also the title suit has been filed.
Do you have allotment?
Yes, LPC.
What the LPC says? It's a UPR 1 or what?
It is ICR Capital Region. ICR Capital Region, my lord.
Where is your allotment?
LPC here. Page 15, my lord. It is start from page 15.
15.
15 on 5. It is start from A series. These are my lane. It is all within the capital ICL region. Duly issued by the Deputy Commissioner, Itanagar Capital Complex.
Which land?
Lane at Likhi village.
Lands. Which one? There are a lot of land possession
Yes,
certificates.
yes, my lord. All these are my lane. This all land are my lane, and all these lands are whatever I have.
The stay is in respect of all this land.
Yes, because that
This
is
is
one
separate
big.
land, separate land. How many? 1, 2, 3, 4, 5.
Though
5 land possession certificate.
yes, it comes under within same areas. Separate, but it comes within the same area. All land are belong at Likhi, name of the area which is situated at Likhi, and issued by the LPC is issued by the Deputy Commissioner Capital Region. All of my land.
Lekhi village comes under capital.
Capital ICR region.
Where Dikrong comes under capital? Dikrong River,
Dikrung River is a jurisdiction between Tuimuk and capital
so
region. Okay.
Dikrong River,
Hmm.
from here, left side is Doimo. Right side is capital.
Yes, the right side is
Okay,
capital.
yours is
At right side.
Nahalagan side.
Yes, Nahlang side.
So all the land
That is what
towards Nahalagan side
Nahlang side, my lord.
comes under capital.
Comes under capital, my lord.
Yes,
Your Lordship, if I may take your Lordship to the page number 23, your Lordship.
that's me. Page 23.
Yes, this is, a reference has been made in the impugn order, your Lordship. I'll just take your Lordship to
Hmm. Page 2, 3.
2-3, your Lordship.
This is
The title suit which has been reflected in the impugn order.
okay.
Lordship, if then come to page number,
The, in
20.
this,
this was filed by the complainant who had made a complaint against the
Petitioner.
present petitioner. your
okay,
Lordship.
against whom?
This is
Against
against some other person.
some
your Lordship.
other-
Okay, not against him,
Not
not-
against him.
but in
And
respect
then-
of the present land.
Yes.
No.
I'll just make an explanation, Your
Ah.
Lordship. At page number 28, your Lordship will then come. This is the description of the land, your Lordship.
Okay.
You will see plot 1 and plot 2, your Lordship.
Hmm. Village UPia, location of plot,
Plot 2, your Lordship.
plot number 1, village UPia 1.
Yes.
Yes, and so. Plot 2,
There is plot 1 and plot 2, your Lordship.
yes.
Title suit with regard
Which
to
one is to be referred?
both the plots, your Lordship.
This is location of plot, village UPia 1.
Yes, UPia. We have no connection with this land.
Hmm?
We have no connection with this land.
Okay, the title suit is not connection
Yes.
with your land.
Hmm.
Why you have annexed this then?
Just to show that on this basis of this land, they are making reference in the executive orders.
In the executive order, this title suit has been referred.
Yes. Sir.
Refer as what?
I'll just come to page number 62, which is the impugn order, your Lordship.
Okay,
Second paragraph, your Lordship.
Hmm.
will see. Whereas it has been brought to official notice that the above stated,
second paragraph,
yes.
60. Okay, where is,
Whereas it has been brought to official notice that the above stated plot of land is already sub judice before the Court of Civil Senior Division Papumpare, District Papumpare, UPI in a title suit between Gyamar Takar alias Bharat versus Tana Kochi, son of so-and-so, UPI, which is still pending trial and final disposal, final disposal. Therefore, it is learned that Sri so-and-so has received legal notice and even sought the information of Sri Nabam so-and-so, but till that date, there is no any justification, reply or cooperation from this side of Sri Tarhari for amicable settlement. Whereas there is an apprehension that while that a volatile law and order problem has been cropped up within the jurisdiction due to the above stated land so-and-so. Now, your Lordship will see, we are not
you are not
he may not be a party
not
to,
cooperating.
yes, he may
according-
not be a party to that title suit, your Lordship. However, the title suit is sub judice before the learned trial court, your Lordship. Now, when the matter was pending in the title suit, your Lordship, that's where a complaint was made by the respondent number 2 that the present petitioner has made an encroachment to the disputed land, which is already sub judice before the trial court, your Lordship. That's when the case was taken up and the executive order was passed in terms of that.
Okay, so according to these two, and the title suit pending before, or according to the contesting party in that title suit,
Yes,
the land falls under UPR. And that is why the executive magistrate, on receipt of the complaint,
yes,
has passed this order.
yes. Now, also your Lordship will see that land, as per the AP Land Settlement Act, your Lordship, only the Deputy Commissioner has the authority to issue LPC. That does not give him the power to entertain all the complaints with regard to 164 in all these circles where there is already an executive magistrate, Your Lordship. Now this, since the entire land falls under the circle of Doimuk, Your Lordship, the executive magistrate who have the jurisdiction under the circle of Doimuk is the one who has taken up this matter, Your Lordship. In terms of jurisdiction, Your Lordship, there is no denial that the executive magistrate has rightfully invoked his power under 164, Your Lordship.
Okay, then we'll call for record then.
Please,
That,
Lord.
My lord, even if even if any stay order has to pass, the magistrate cannot, when the case matter is pending before the civil court.
No, there is no power to that.
So it is for the court to pass such any orders of status quo also. And otherwise also, in the
No.
title suit itself, which is reflected in the page number 28, well reflected in the page number, their claim is of UPI 1, plot number 1 and
Just a
plot
minute,
number
just a
2.
minute,
Yes, Your Lordship.
And
If-
I have a
just a minute.
clear,
just a minute. If the case is pending, if the same, regarding the, or in the same plot, if the case is pending
Yes, Your Lordship.
with regards to the disputed land,
Yes, Your Lordship.
the case is pending before the civil judge, senior
Yes.
division,
Yes, Your Lordship.
then this party,
Yes.
why lodged complaint before the executive magistrate?
Your Lordship will
Could have
see,
been here,
yes, Your Lordship will see that,
or made party,
yes, Your
someone
Lordship.
encroached.
Your Lordship will see that in terms of title suit, Your Lordship, there is a provision of injunction, Your Lordship. If that is given or not in this case is a different thing that they have
Could
not
have
annexed it,
filed
Your Lordship.
injunction,
Now,
making him-
now
making him-
now the trial court who have the jurisdiction to try the title suit will only do according to the provision provided under the CPC, Your Lordship. Now, the next thing is that 164 is more particularly 164 of
No,
PNSS is,
No, the case is subjudiced.
yes,
He himself is stated, say
Yes.
that case is subjudiced.
yes, Your Lord.
Then if the case is subjudiced before before
Yes,
the civil judge,
yes,
then in the civil judge itself, the complainant would have filed, implead him and obtain injunction.
there is no bar that the section under 164 cannot go simultaneously with regard if there is any title suit pending before any court, Your Lordship. That particular law is settled, Your Lordship. There is no bar that both of these proceedings
Can you satisfy the?
Yes, I'll satisfy if
Hmm.
on the next date, Your Lordship.
Hmm.
More particularly, why I'm stating that is 164 is only with terms of possession, Your Lordship. Your Lordship, it takes up 164, Your Lordship. I'll just satisfy Your Lordship. Because
Settlement
164
different,
is only with regard to possession.
So-
The magistrate would not see who has the title or,
Here is the case, here the case is already pending before the,
yes, yes,
before the court.
yes,
Not that it's before magistrate, we can understand that if there is a dispute between the parties and 164, a magistrate can pass order
yes,
for maintaining status quo there till the settlement of
yes,
decision of the title.
yes,
But then here is a case where the title suit is already pending.
yes. With some other, but title suit was more particularly against some other person.
Now
Your Lordship.
supposing if he has impleaded wrong party, then he has to implead the present, the right party
Your Lord-
in title suit itself.
Your Lordship, I'm not aware of how the trial in title suit is going on, Your Lordship.
Hmm.
However, Your Lordship, in cases of this nature, Your Lordship, when he is not a party, Your Lordship, subsequently there is an interference from the third party, Your Lordship, to maintain the peace and tranquility of that particular place, Your Lordship. There is no bar to invoke 164, Your Lordship. That's what the,
Okay, call for the record.
the executive order hasn't passed on the basis of the title suit, where
On-
I have no connection, and there cannot be two parallel proceedings also, as per the CPC.
I'll just,
She will satisfy on the next day.
Yes.
In this.
My lord,
Mr.
my lord, till such period, till the next date, interim may be given on the executive order.
Direct counsel for the petitioner. Also had Ms. Ginny. Learned additional PP. For the state staff. By this application under section 528 of ENSS 2023, the petitioner prays for setting aside challenge the order dated 28/7/2025 issued by the executive magistrate Doimo, whereby the petitioner, whereby, just a minute, where is the operative portion of the order?
At page number
60, 62.
and the 62 is typo.
Para?
It's more visible.
Para 63, Your Lordship, last para.
Whereby the executive magistrate exercising the power under 164 of the BNSS has directed directed the petitioner to stop the land development or quarrying activity in the disputed plot of land located at UPA 1. Stop. Huh? Stop. Huh? The land council for the petitioner submits that he is under the disputed land belongs to the land council for the petitioner submits that he has the land possession certificate over the disputed land. And it is located at Lekhi village, which comes under the Deputy Commissioner of Capital Complex, Itanagar Deputy Commissioner, Itanagar Capital Complex, and under the UPA 1.
UPA 1.
Issue notice, call for the record. Since Ms. Jenny appeared and accepted notice on behalf of the third respondent, no formal notice need be issued to the third respondent. No, who is the other respondent? Who are the
Your Lordship, respondent number 1, since
petitioner will take steps upon the respondent number?
will be only for the respondent number 2, Your Lordship.
Oh, you are for respondent number?
2, Your Lordship.
Okay, 2.
Since the Deputy Commissioner has been made a party,
Just a
Performer
it's a
party.
only performer.
Okay.
on the government will be appearing for respondent number 1 in that case.
Hmm.
It's just only performer. It's not very.
You are only for
permitted.
2.
Only for 2, Your Lordship.
So 1 is to be represented by
By the
government advocate.
Government advocate, Your Lordship.
Anyone government advocate? Respondent number 2, huh? No formal notice need be issued to the said respondent, but the petitioner shall take necessary steps for causing of service notice upon the respondent number 1 and 3. by a registered post with edit as by usual process within 3 days from today. So, see, what we can do is the the petitioner has submitted, this is a complaint, your page 64.
Page 64 is a complaint. Complaint, complaint regarding the complaint of the complaint upon which the Gyamar Thakur has issued and due to which the executive order is issued. It was expression that
So when do we list it? When do we list it?
Your Lordship may list, because the notice has also to be on, your Lordship may fix this on 21st of October, otherwise
List
22.
it, October,
Because the notice would not be possible within a
Okay,
week. Your
private.
Lordship. Yes, private respondent, your Lordship.
Okay.
As far as this, your
That-
Lordship has rightly pointed out that a report was called on 31st of July 2025, your Lordship.
very bad, must have,
That-
some
that-
order must have passed.
That if was
That can be disposed.
within the knowledge of the petitioner, they ought to have been brought before
Yeah.
the court, your Lordship, because on
That there
31st,
the jurisdiction must have been clarified.
yes, on 31st 7 itself, they have given an application to the magistrate, your Lordship.
Hmm.
So on the 31st itself, there ought to have been a report, your Lordship. If
There
that-
must be,
that-
there must be.
there must be, your Lordship. And if that was within the knowledge of the petitioner, it ought to have been brought
Could have
before
been.
the,
Could have been incorporated there in the petition.
because since your Lordship will see this order does not,
List this matter again on
20,
21st October.
yes, your Lordship.
So,
Answer.
This, can we say that this application is for clarification of the jurisdiction? He has not met, he has stated that it doesn't come under UPR.
Yes, and if, since your Lordship will also see that it was dated July, now we are running on September, your Lordship.
Yes, yes.
So
that is
if the record is called from the respective office of the
Okay,
executive
then,
member,
My lord, till such period, the interim may be created. The operation of the executive,
See, you are nowhere in the title suit. You are not even the owner,
but I haven't,
not even the party. We do not know which land it is. So
but my lane, I have shown clear, my lane is,
according to you,
different.
this is not,
They have unnecessarily issued this order. So
according to you,
till the next date, the interim may be
See.
stay of the operation, impugn order, operation of the impugn order may
see,
be.
according to you, the both land under contest under the title suit, and also the land mentioned by the executive is not your land.
That is,
Then
the title suit under which the land falls, that is not my land. It is at UPA one, the petition, the plaint of the plaint itself,
it is not connected with you.
but I haven't hampered, my right has been hampered, my plot has been hampered, such time, at present. My work has been stopped. I am debarred from my own land, upon which I have a clear LPC of a capital region. So why should I be suffered for a wrongful executive orders? So till such period, if the operation of the executive order is not stayed,
Okay.
so very purpose of
Let me-
approaching.
If the land of the petitioner doesn't fall under the UPR 1, okay,
I'll just clarify, your Lordship,
The-
just a small submission, your Lordship.
hmm,
Since this executive order also reflects the title suit, your Lordship.
Hmm.
In the complaint, there might have been certain documents to justify the case of the complainant, if so, your Lordship, because there is a reflection of this title suit, your Lordship. The two plots in the title suit,
hmm,
if the executive magistrate was satisfied enough that his land has,
Okay,
the encroached land,
clear that if the land of the petitioner doesn't fall
We didn't do remove
Within-
circle.
within UPR 1, which within UPR 1
disputed
under the jurisdiction of the executive magistrate Doimuk.
Yes, my lord.
At the end, is not connected with the title suit. What is the title suit?
Title suit number,
Not connected with the land, a disputed land in title suit
27, title suit,
27, 2022, comma,
Hmm.
the operation of the order dated 27, 2025, passed by the executive magistrate Doimok shall remain state till
My
the
lord.
next returnable date.
my lord, order dated 28
If
July.
it is not connected with.
Yes, my lord. Yes, I'm satisfied. If not connected.
Okay.
Order dated 28, my lord, 28 July.
But then if it is connected,
Yes,
then you'll have to.
yes,
face
yes,
the
I have to
consequences.
bear it. Then I should not be suffered. If the jurisdiction comes, or it comes within the jurisdiction of the Imo circle, I'm ready to bear the sufferings.
No, just a minute. Huh? Not state, huh? The lane of the petitioner shall not be disturbed till the next returnable date. Who said that?
Hmm.
If it is not connected, he will not be disturbed, not staying the order.
Your lordship on this.
Hmm.
Lordship once more particularly does not even see the, while passing the order under 164, your lordship. The magistrate does not
No,
look
no.
into the
What it is
titles.
submitting is as per this petition. The magistrate doesn't have a power, jurisdiction at all,
Yes,
because it doesn't fall under UPR.
yes.
If it falls under UPR, automatically it
Yes.
will have effect.
Yes, have effect.
But in this order is, they have not particularly challenged the jurisdiction, your lordship.
What
We
they
have
have
challenged the
challenged?
jurisdiction.
What they have challenged?
Their challenge is more particularly that their issue is with regard to that they fall is or their land does not fall under the disputed land, you know.
We challenge regarding the jurisdiction. That is how we approach.
Let us see your prayer.
Your lordship will see that it's at page number 10, your lordship.
Hmm. Where have you challenged the jurisdiction of the executive magistrate, the MOOC? Counsel for a petitioner? Petitioner have no land within jurisdiction.
I've challenged in paragraph 5, paragraph 6. Five and 6, my lord.
Without jurisdiction, clearly made. Is challenging the jurisdiction of. So if he doesn't have a jurisdiction, then he will not be disturbed. Okay?
DP obliged.
Your lordship has also called for the record, your lordship,
Yes, call for the record.
registry.
Item number 2.
Wait, please, Lord.
Yes.
The petitioner is putting to challenge the FIR dated 2nd of September 2025, filed by the respondent number 2 against the petitioner, and pursuant to which case has been registered under section 329(3) and 131 of the BNS, which is what is basically a dispute over title between the petitioner and respondent number 2. Unnecessarily, my lord, this case is adjourned. The lordship will kindly at page 24. I'll just briefly give the facts. Now, the petitioner's family has donated my lord land for construction of school at Moin, as Sangdupota Circle.
Petitioner's family?
Yes, they has donated land for construction of the school. Now this respondent number 2, page number 24, madam.
Page 24. This is order.
This is an order passed by the estate officer.
Mm,
Now this respondent number 2, purportedly on the basis of a, my lord,
Respondent number 2, okay. One is, wait, okay, 2 is individual. Yes,
he started claiming over the land on the basis of so-called gift deed executed by the petitioner's uncle, which includes a portion of the school land which the petitioner's family has donated and my private plot of land. So since the school's land was involved, complaint and this proceedings under section 4 of the Arunachal Pradesh Public Premises Eviction Act 2003 was started. Your lordship will kindly have the third paragraph. I will
of the,
of the order.
okay. You are the petitioner is the complainant.
Yes.
The petitioner is the complainant in the PS case.
No.
Oh,
Case has been registered against me.
against you.
Respondent number 2 is the complaint.
Okay, respondent number 2.
Yes.
You, the land you have donated, land was donated by you
Yes.
to the school.
Yes.
And the petitioner number 2 has,
He
Or
started
is
claiming
claiming.
over the land,
uh,
including a portion of the school's land,
okay,
on the basis of a sale
deed.
deed ballot that was purportedly executed by my father, uncle.
okay, your uncle.
Yes, my lord will kindly have,
So your
order.
complaint is against you.
yes,
Uh,
saying that I have started construction over the plot of land. Civil dispute. You are claim-
that is over your land,
Yes.
not over, not,
Whatever
over
it
the
is, my
school
lord.
land.
The respondent number 2 is claiming the land on the basis of a sale deed,
Hmm.
gift deed. It's a civil dispute. Go to the civil court.
Yes,
How can there be a, my lord, in fact, both the sections does not even apply. I will read it also. My lord, may kindly have the last paragraph and whereas, just to show on what basis he is claiming.
Hmm.
It is claimed that, as my lord got it, that keeper, is the respondent number 2, paid a sum of rupees 5 lakh such and such to Mr. Chakum Pino, that is my uncle,
Hmm.
over the course of years beginning 10th August 2008 in return of the present plot of land under contention. So it is on the basis of a money paid. So the sale deed also here we have annexed, I will show. So it is on the basis of some money paid over that plot of land. However, my lord, your lordship will kindly have page 25. Last paragraph.
Hmm.
The claim sale of land by Chakum Kino to Kipa Kanye does not stand the test of scrutiny due to absence of witnesses from the family, village, and the legality of resale of government land without following due procedure. In consequence, the claim of Kipa Kanye over the school land and by extension the land of 3 other individuals, that includes me, in the vicinity is held to be illegal and should be forfeited. So thereafter, my lord, direction to my lord, remove all constructions. This is in 2019. He started construction at that point of time. Order.
who started constructing in the 2009?
Respondent number 2, my lord.
Who started construction?
Oh, yes. So, since it was the school's land, by this order dated the 2nd of August 2019, my lord, he was directed to remove all constructions. This is a proceedings under section 4 of the Eviction Act, my lord, 2003.
His construction was stopped.
Yes. So against that, my lord,
Hmm.
he ought to have filed an appeal under section 12.
Yes,
He did not do that. He challenged that order by way of a title suit. Before the Civil Justice Senior Division, your lordship will find
against who?
against the order dated passed by the estate officer.
Okay. So
There is an
making,
appeal provision, my lord.
who were the respondent there?
I was there.
Okay, you
Others
were
were
also
there.
made as one of the
I am
respondents
respondent number 2. So
in
this,
the title suit.
yes. This title suit was dismissed by the order at page 43 on the ground that there is a provision for appeal. There is a bar under statute to take up any order passed under that act, 2003 act. So the suit was dismissed, my lord. Then, my lord, he filed an appeal, civil appeal, at page 52. This was also dismissed,
Before the
district judge.
district judge.
Yes. So this was also dismissed, my lord.
Okay.
Then what he does, approaches the deputy commissioner, my lord, now under section 12 of 2003 act.
What is section 12?
Section 12 is a provision for appeal,
Before the deputy commissioner.
deputy commissioner,
Okay, then
against any order passed by the estate officer.
Page?
That is at page 61. These are just facts I'm just pointing out.
yes, yes,
These are admitted
that's for understanding.
Since he was approaching all these honorable courts, filing misconceived petitions, there was a delay. So at page 92 is the application for condonation of delay under the section 5 of the limit, 1880 days
So delay before which court?
before the deputy commissioner.
Okay, for filing appeal.
Yes.
What happened then?
The deputy commissioner has no power to condone the delay, just like an election tribunal, because it's not a court.
Hmm.
Once the act provides that it is 30 days, you have to file an appeal. You have to file an appeal under 30 days. But what the deputy commissioner did is he allowed the interlocutory application and condoned the delay at page 118. This is dated 30th of August 2024. Condoned the delay of 1880 days. And the appeal was admitted. That's my report.
Okay. Okay.
Now the deputy commissioner has absolutely no jurisdiction. It's a tribunal, not a court that can condone a delay. So we approach the honorable court at page 123. The honorable court has stated the order and the petition is pending before this honorable court.
Now, the.
Now, my
the
lord, he
petition
has
is-
filed this
the
FIR.
petition is still pending.
Yes, there's a stay.
Okay.
The stay order is at page 123.
Yeah.
Now I received this notice at page 127. Thereafter, I procured the FIR. Your lordship will find it at 132. The bare reading of it will reveal that it's a civil dispute.
Now,
No allegation.
after this court order, where is the FIR?
FIR at page
when he lost?
132.
32.
Yes,
When he lost this FIR?
2nd of September.
Over the same plot of land.
Yes. And FIR against Boken Kino for forcefully construction a building at my private land.
32.
Over the dispute.
FIR at page?
132.
Okay, 130.
May-
Yes.
With due respect, I beg to state that I have a plot of land at Moin Village under Group of the Circle, where Boken Kino is forcefully constructing a building. I have been living under the position of land measuring such and such, located at Moin Village under Group of the Circle since 2008. I have purchased the land from late Kinu Chakum, late father of Sri Boken Kinu. Accordingly, we had executed sale deed dated 6/11/2010. So, my lord, he is basing the claim on the basis of a sale deed. 16/11, in the presence of witnesses, Sri Sasensa, since then I have been taking care of the land without any obstruction over the land. Suddenly, after 10 years, these are all false. Dispute started when Yadev Kinu, the owner of the adjacent land, started constructing a boundary wall in himself. As such, the petty squabbles become very hot and serious dispute between them. Moreover, the family members of late Kinu Chakum supported her, and further they alleged that I had enclosed the land of government boundary school, primary school Moin, an area measuring such and such, for which Boken Kino, the then chairman of SMC, issued a circular convened a meeting on such and such in the presence of GBs, Panchayat leaders, such and such to dispute the. On the following day, Sri Yadav Kinu being the owner of the adjoining plot of land, lot unwarranted and complains the school committee pursuant thereto the circle officer Sangdupura without conducting proper verification arbitrarily declared a portion of my land as government land, having been misled and influenced by local MLA such and such, agreed by such illegal and unjust action, we have further learned civil judicial magistrate as well as the Honorable High Court, for which is pleased to direct the matter to be adjudicated the circle officer. The presently, the dispute remains sub judice before the office of the deputy commissioner. The land in such and such nowhere connected with forcefully constructing a house in my private land. So, this is the matter. On the basis of this, 329, 3
So
and
according to you,
131
this
BNS
land,
has been registered.
21,000 square meter is no more connected with the full land, but now
This is what he is saying. But the fact remains, he is making that claim on the basis of the sale deed and money receipt, which your lordships will find from page 134 onwards. This is something that the circle officer has said. It has not been proven. Of course, he is not the authority. It will have to be proven before a civil court. So this is the money receipt, and there are various other money receipts on the basis of which making the claim. So where is the question of minor at this stage, minor trespassing and 130? 131 does not even come. There is no allegation in the FIR itself. But we will kindly have 131 of the BNS matter. What I am submitting, my lord, he is making a claim over the title of a land on the basis of some money receipts. So this will have the civil court, my lord. Title has to be decided. And as far as 131 is concerned, there is no allegation of 131. My lord, will kindly see. My lord, go ahead. 131 BNS. Both sections are in fact not attracted on the basis of the allegations made in the FIR.
131.
131.
Assault.
Punishment for assault or criminal force, otherwise they don't grave provocation. There is no allegation regarding any FIR. Am I clear, man? There's no allegation, man. Then your lordship will have 329(3), that is the other section. Three 29.
Yeah.
3.
Human trespass.
Whoever enters into or upon property in possession of another with intent to commit an offense or to intimidate, insult, or annoy any person in possession of such property or having lawfully entered into it or upon such property unlawfully there with intent to intimidate, insult, or annoy any such person or with intent to commit an offense is said to commit criminal trespass. 3 is punishment. Even this allegation is not there. And regarding possession, the circle officer said he is not in possession. The said officer, this is a purely a civil dispute, my lord. But I am praying, my lord, we issue notice at this stage, and my lord, any action pertinent to the FIR may be, my lord, state.
Yes, your lordship. Lordship may call for the record, your lordship. CDA, lordship.
Heard, Mr. Deepang, Land Council for the petitioner. Also heard, Ms. Eugene Wu, Tara Edison PP for the state. Para. By filing this application under section 528 of BNSS, the petitioner setting aside and passing of the FIR number 23/2025 dated No, FIR dated 2/9/2025, registered as which PS case number?
Balijan PS case number.
Balijan PS case number
Just a minute.
23, 2025, under section 329, within bracket 3. And Cognizance 131 of BNS 2023. Papa. Scroll the scanned copy of the case diary. Issue notice. Next clinic. Planet Edition P3. Appeared and accepted notice on the list. Respondent number 1, state respondent. No formal notice needed. The petitioner shall take state upon the respondent number 2 by a registered post with AD. As well as by usual process within 3 days from today. Please this matter.
On your lordship,
23, 24.
24th, your lordship,
24th of
September. Yeah.
September. 24th September.
I'm making interim prayer.
Hmm?
I'm making an interim prayer. Prima facie is a civil dispute, man.
So consider interim on that day.
My lord, it's unnecessary harassment. I am being called by the police, my lord. My lord has seen prima facie is a civil dispute, my lord.
Whether, have you given
His-
statement? Have you
His
given
claim,
statement?
my lord, the FIR itself says is on the basis of money
That is
received.
fine, that is fine. Whether you have given any statement before the police, not yet.
Yes, I have given.
You have already given.
Yes. I was called,
So
page
then-
127. I have given my statement.
Okay.
Unnecessary one.
So we'll see, because you are not in, you are not going to be affected at the moment. So for
Madam,
24th,
How can your lordship,
Lord.
my lord, allow a proceeding to go in this manner, my lord?
And in
When
fact,
there is a prima facie case.
in fact, I concede with my
Yeah.
senior,
How
learned
can this be
counsel,
allowed, my lord?
because though there is no bar per se, your lordship, however, this clearly seems to be a civil suit, your lordship. I don't have any objection if the
no,
investigation.
yes,
My lord,
Okay.
The FIR itself, my lord, making a claim on the basis of a document.
this is matter again on 24th. In the meantime, the case, scan copy.
Scan copy.
Okay. In the meantime, the further proceeding of the further proceeding of the Balijan PS case number 23, 2025 shall remain till the next returnable date.
Right.
Item number 3,
Item?
Lordship, this is the petition which I have withdrawn day before yesterday
Okay,
because of here. So I have made the necessary correction on that. Lordship, here,
what correction was necessary? Okay, yes, please.
yes, Lordship, it has been charge sheeted under section 406, 406, 420, and read with section 138 of NIA. Lordship, as far as I am aware, Lordship, and law is very clear on that. Police has no authority to charge someone on under section 138 of NIA.
No complaint.
No, directly charge sheeted under 138.
Okay, no complaint was lodged before the magistrate.
No, it has been charge sheeted directly under 138 because
138.
yes, of NIA, and the police has no authority on that.
Yes.
Because it has to go through the magistrate. by
After
means
charge
of-
sheet, the
And-
court taken cognizance.
Oh, yes, Lordship, it's now pending before the Chief Judicial Magistrate. Bombay.
Any process issued,
No, till date, no.
but charge sheet filed.
Yes,
Yes, 138.
No, Your Lordship, remove the 138. I concede with my learned friend, Your Lordship. 138, the police cannot, there has to be a
Cannot,
complaint.
huh.
But then there are other sections, Your Lordship, which was focused on the first date, that is when the matter was withdrawn, that is 406 and 420, Your Lordship.
Lordship,
Cheating and criminal breach of
As
trust,
for
Your
what-
Lordship.
Any
Just let me
Any
finish.
case made out?
Yes, Your Lordship. Your Lordship, I have on the previous day, Your Lordship, since the interim was being prayed for, Your Lordship, I have Lordship to the notice that when though they tried to portray it as a civil case of civil nature, Your Lordship, I have brought into Your Lordship notice that during the investigation, Your Lordship, it came to the notice of the investigation getting officer. Therefore, I was also making an impression to this honorable court that along with the charge sheet, the statement of the accused as well as other witnesses, since they have annexed the charge sheet, they deliberately did not annex the other documents in the charge sheet, Your Lordship.
Hmm.
It has only come to know from the charge sheets, a bare reading of the charge sheet, when the company was closed, Your Lordship. During the entire time, the accused did not inform the party, Your Lordship. In fact, he has delayed. He did not pay he did not make any payment, Your Lordship. Subsequently, Your Lordship will see that this
Yes.
honorable court has granted him an interim to appear before the IO, Your Lordship. He did not appear. Thereafter, on many occasions, after giving a reminder, the state has filed an application for
In which
cancellation,
case he was asked,
cancellation of his bail, Your Lordship.
whether he was directed to,
Yes, he was
appear
directed
before the
to
IO.
appear.
He did
before
not
the-
appear.
He did not appear.
in connection with this
The
case,
same case, Your Lordship.
it was in AB.
Yes, in AB, Your Lordship. He did not appear. Thereafter, there were many notices given, Your Lordship. Finding no other way, Your Lordship, the state has approached before this court for cancellation of the bail, Your Lordship. After third or fourth hearing before this court, Your Lordship, that's when he appeared before the IO, and that's when the matter was withdrawn, Your Lordship, being instructed, Your Lordship. After his statement, the matter was charge sheeted, Your Lordship. The 138, I completely concede with my friend, Your Lordship. But the charge also contains some other sections of BNSS, Your Lordship. 406 and 420, Your Lordship.
of IPC.
IPC.
As Lordship,
We'll call for the record.
Lordship, as
Yes.
for.
Let us see, let us examine.
Because to satisfy this
Now-
court for.
Now, even now,
406 and.
are you insisting for the stay interim
Yes.
also? But then you see, at the moment, you are not going to be adversely affected by any
Lordship,
order
if
passed by, because
granted,
you will be
also-
given only the copy of the charge sheet on the next date.
Lordship, if I may, Lordship, in the FI itself, it's very clear. And
Maybe.
as for section 406 and 420, the intention.
See, the charge sheet filed, since the charge sheet has already been filed, and then the magistrate will take care of it.
Yes.
And then you can also make a prayer before, at the time of hearing on the question of charge. You can make this prayer for discharge, automatically that will be done. But then at the moment, you will not be probably, see, you are protected by the interim in the bail,
Yes.
maybe, no problem.
Lordship, the problem is, Lordship, he was unable to appear before the investigation agency to give his 161 statement because of his health issue. Now also he's going through some health issue. If he is called for, he may not be able. to appear. That is the issue.
It is always better to get discharged or acquitted by the trial court.
Lordship,
And in fact, Your Lordship,
Lordship, para 2 of the FIR clearly states that the
Maybe, but
are
then
not
that
in-
will have to be examined by the magistrate since charge is already filed.
Lordship, if records may be put an interim, it can be cleared on next date for this.
No, sir, see, the learned magistrate himself may raise these questions. Where is the case? Why you have to file charge sheet?
even on
Lordship,
the,
the
even on
fact-
the- if there is a case, because on the previous, all the occasions, he had an ground of medical, Your Lordship.
Hmm.
However, the prosecution also could show that he was in fact not on treatment, had on many occasions traveled to many places that by the CDR also was. That's another issue because it was
Lordship,
during the
Then he can-
investigation. Your
See,
Lordship.
now at this
But-
stage, he can authorize the learned counsel to appear
Lordship,
on his behalf.
By bare perusal of the FIR
Maybe.
and the prosecution is.
We'll examine the record then.
Like, it is
We'll examine
clear
the
that,
record.
Lordship, the crux of the matter is non-payment of dues only. And there is a civil remedy for that. Non-payment.
If
of
that,
dues
if that be so,
on-
automatically it will go.
And the intention of cheat should be from the inception of the offense. Lordship, here is in the FIR in paragraph, the business
FIR is at page,
page number 28. Page number 20,
hmm,
paragraph 2. Married.
hmm.
During October 2021, I was approached by Sri Kasim Jindal, husband of so and so, proprietor PPK Enterprise, village so and so, assist his wife in business of PPK Enterprise with a proposal to provide 3 number however 10 billion dumpers and also to them for employing them with mining and network. Lordship, this is the person who has approached the informant. There was no connection between the petitioner's company with the informant at this stage. The initial agreement was between the PTK Enterprise and the company of the petitioner. So there cannot be a intention to cheat the informant from the inception. Further, later on, the informant approached the company of the petitioner to grant her work order. And it's not,
This same civil appeal,
No,
civil matter.
it's not
No,
like
it's not a
Lordship,
civil
there is
matter. I'll
no-
just
no-
satisfy your lordship. I'll just satisfy. Your lordship, he is hampering upon the FIR, your lord. FIR at page number 29, your lordship will see from paragraph 4, your lordship. Though the first payment was made with TK so and so, your lordship. Subsequently, he had made an agreement with JUD Siemens, your lordship. Your lordship will then, if I may then take your lordship to, and therefore I was stressing on the fact that all the documents in the charge sheet has not been submitted before this court, your lordship. If I may take your lordship to page number 36, your lordship.
No, in the FIR, what I'm saying is in the FIR, prima facie, it appears the matter pertains to
Yes.
civil.
and
Yes,
Lordship,
I'll
there-
just-
it's not like we have not paid
I'll-
the amount.
Yes.
First bill has been
this
cleared.
is- Your lordship will see that this is not a case where quashing of the FIR during the pendency of the investigation is being made, your lordship. This is a petition for quashing of the FIR as well as the charge sheet, your lordship. Now, when the charge sheet has been made on basis of which document and basis of whose statement the charge sheet has been filed has to be looked into, your lordship. If I may take your lordship to page number 36, your lordship. I may read the first line, your lordship.
Yeah.
It starts from middle of the line, starts from alleged accused person, Sri Adarsh Junjunwala, being the director of the UD Mining Network Service Private Limited, did not inform the complainant about the shutdown of his factory and kept the vehicle retained under his company, your lordship. So I will just satisfy your lordship only on one submission, your lordship. Your lordship is well aware, as I already pointed out, this is not a case
No,
of
what is the offense?
offense is 406, 420, criminal breach of trust
Breach
as
of
well
trust.
as
Okay.
cheating, your lordship.
Okay.
Now, your
So
lordship will
he was
see,
not informed.
now your lordship will see a person coming to the court
Hmm.
for praying for an interim, your lordship. It is the annex the entire document, your lordship.
Anyway, so.
Lordship.
Now, I'll
just
just-
on the
Gatso,
page-
Gatso, I have understood. Mr. Gatso,
Yes, Lord.
so now at the moment, because we'll of course fix third date. Let us see the
Lordship,
record.
that's
Let us see the
short period
record.
cannot be Possible, since I have to take steps on respondent number 2.
See, if it appears that in the earlier occasion also, at the time of bail also, you are the one who, otherwise the relief could have been granted. AB was also granted to
Yes,
you.
Lord.
You did not appear. And then now also you are praying only for the timing and then the difficulties of his
Still
appearance.
returnable debt.
But in any case, there is a case, you see, this is a process.
Yes.
This is a procedure
Yes.
where when being an accused, he has to appear
Yes, Lord.
somewhere or other,
Because of
before the police once, or before the court also. And then if you're trying to avoid that all the time, it will be difficult. See, you have to cooperate with the first of all, you have to cooperate with the police as well as to the court
In
to
fact,
show your bona fide.
non-bailable warrant was also issued on the previous
See,
occasions.
see,
Lordship, because of his
My-
health issue,
Okay.
he was not.
hard, Mr. Gatso.
Lordship, kindly interim
Hmm.
may be considered, Lordship.
Sharing Gatso Lane counsel for the petitioner. Also had Ms. Chini, Lanet, additional PP for the state respondent. So now you have mentioned GR case.
Yes, Lordship.
Okay, by filing this application under section 528 of the BNSS 2023, the petitioner of the GR case number 96, 2023, arising out of the Balapung PS case number 19, 2023, under section 420 and 406 of IPC. It's IPC
Yes,
Yes,
your lordship.
2023, okay. Read with section 138 of NI Act. Huh? It is submitted that the matter pertains to civil dispute and the NIA Act doesn't attract in the instant case. Stop. Huh? Call for the trial court report.
Your lordship, scan.
Just a minute. And then question of pending before the which court?
Chief Judicial
Chief
Magistrate.
Judicial Magistrate. Bomdila. Okay, stop. Okay, then call for the scanned copy of the trial court report. Issue notice since
Lordship, interim may kindly be considered.
Miss Jenny, learner additional PP. Is present and accepted notice on behalf of the state respondent. No formal notice is called for. Staff, the petitioner shall take steps upon the private respondent number 2 by a register post with 80 as well as by usual process. In 3 days. 3 days from today. List this matter again on.
Lordship, kindly.
On 2 week, after 2 weeks, your lordship.
After 2 weeks
2
would be.
weeks, it will not be possible since I have to take steps on the respondent number.
Yes, you have, the notice has to be gone to the respondent, your lordship. Otherwise, I
Okay.
could have taken a
Then when do you
short.
want?
Lordship, kindly interim till returnable date, Lordship.
No, when do you want? 2 weeks, we say it's not possible.
2 weeks, because after 2 weeks, there is puja vacation, your lordship. That will suffice.
Hmm?
That will suffice, your lordship.
Then we'll fix
Af-
on
On
25,
24, not 25, your lordship, because that has to come and the notice has to be gone, your lordship.
then when?
Because the October vacation is also there, your lordship. Even
After
the-
vacation?
After vacation.
Lordship, kindly, interim, because Lordship here, the
Why you are insisting on
No,
it?
no.
Because this is not going to affect the, probably in the first, you will be provided with the copy of the,
definitely Lordship, but.
then you don't have to appear also. They
But-
can be represented by the advocate also. You can authorize if there is a health issues.
Lordship, here issue is Lordship, if no payment was made from the very beginning, then maybe this case is there. But we have made some payment for the bills. On the later date, no bill was placed before. Unable to make any payment, no
Okay.
legitimate payment.
No.
That has,
In the prosecution story itself is there 26 lakhs something has been given to the,
all the
It- it-
documents
See,
of the
see,
prosecution story has not
It
been
it
annexed.
appears that you have a case. But then after perusal of the records, automatically that will go. Don't worry about it. But for the time being, unless we see the records, it will be difficult because there is allegation is something.
If he could have, for fairly submitting a lot,
Hmm.
if he could have annexed all the documents in the charge sheet, your lordship.
Hmm.
There was no occasion of even calling this case record from the
Record.
trial court, your lordship. That could have sufficed your lordship to decide on if there was a case or not even. But then no document,
See,
at least for asking for an
Because-
interim document
because
has to be.
Your challenge is to the charge sheet also,
Yes.
yes,
and that is why.
if granting. interim
See,
of the Lordship-
something he is trying to, it appears that he is trying to at least keep something in dark.
Yes,
It appears.
absolutely.
From the very beginning, it appears from the.
No, Lordship, the FIR is, in the private face is very clear that it's a civil dispute. Crux of the matter is
It will go
non-payment
to
of
civil
due
dispute
itself.
only, you'll succeed, okay. List this matter
On 21st
on
of, as soon
23rd
as
October, okay.
If no,
Item number 6.
My lord, this case,
Yes,
The
my lord,
service
already
of
admitted
notice.
it appears.
yes, my lord,
Already admitted. This has to be listed before for hearing.
yes, my lord.
Hmm.
Since they are not representing, my lord, that
Hmm.
ex parte, my lord, hearing.
Mr. Tito, online counsel for the petitioner is applicant who is present. None appears on behalf of the respondent. To appeal against what?
Appeal against, my lord, dismissal of my,
Okay,
although there's a material, my lord.
you're for husband.
I'm for husband, my lord.
Okay,
There's ample evidence, my lord, that
you're challenging the,
dismissal matter part. That could not have been dismissed, but it could have been granted, there's a case for granting decree of divorce.
divorce.
But despite of this all material fact, well, there has not been.
You want divorce.
Yes, ma'am.
Okay,
And
they are staying
altogether
separately since when?
separately, we are
Since-
staying separately, my lord.
Since
Since many years, my lord. We have mentioned it,
paying any maintenance,
maintenance, my lord, all the child, my child, my lord, that's under my care, and
how many children?
my lord, one, my lord.
Okay, so not giving any maintenance to the wife,
He's a government employee, my lord,
how many employees?
my lord. Teacher, my lord.
Did she contest?
My lord, in the trial court, she contested, my lord, in their evidence deposition also, my lord, they admitted that we are staying separately, my lord.
Separately, but then it was
And
dismissed.
yes, dismissed. And there are certain,
But still now they are not staying.
no, my lord.
Okay, no conjugal.
No, my lord.
Okay.
No conjugal relation. Even while we are staying together.
No application for restitution of the conjugal
No,
right also,
no.
but just lying that way.
Yes, my lord.
Okay.
There's no possibility of
Okay.
reunion together.
Since the appeal has already been admitted, whether record was called for
Yes,
and the
records,
record has also been received.
Records.
Let this matter be listed for hearing after 3 weeks.
my lord.
Okay.
Deeply obliged.
Item number 8.
May I please?
Yes.
This bill application is pending since 6th August, madam.
What?
6th August, madam. 6th
Order.
August, madam. This bill is pending, madam. Now, madam,
What is pending?
this bail application, madam.
This is bail application.
Yes, madam. Regular bail application, madam, prepared by the madam, the mother of the alleged accused person, namely, madam, Akom Yajum Dongo.
What is the allegation?
Madam, the allegation is initially, if Lordship perused the madam, FIR at page number, madam, type copy is at page number 15. Madam, the stories are different, madam. Now, after the investigation, madam, during the pendency of this bail applications, madam, subsequently, madam, the POCSO, the case section under POCSO has been, madam, incorporated, madam. So, madam, page number 15, may I read, madam?
1-5.
1-5, madam,
Yes.
of my bail application, and extra 2, madam. This is the, madam, the application, madam. It is not exactly
May
the,
not read loudly. This is sexual harassment.
so with
Also.
utmost respect and deep anguish, I
No, please. Don't read
oh,
the
I'm
name.
sorry, I miss so and so, district Changlang, so and so, write these letters to bring to your notice a grave matter that caused me immense the emotional and physical and the psychological trauma. That I have been working in the house of Sri Yapu Dongo, located at IG Park Colony, Itanagar, for a long 2 years under extremely difficult and humiliating circumstances. During the course of my employment, I was subjected to continuous harassment and so, most and most disturbingly. Sri so-and-so, Marat accused person, has sexually so-and-so arrested me and so, Marat, for quite some time, madam. Despite my repeated refusals and the pleas for him to stop. He continued to exploit his positions and force himself upon me, and I was terrified and helpless. And he used threats and intimidations to silence me. The situations escalated dangerously in the last week of 29 May 2025 at around 10 p.m. So when I was only not only the emotionally tormented, but also physically assaulted. On one such terrifying day, Sri so-and-so, wife, Srimati Meena Dongwe and so-and-so, and her sister, Srimati so-and-so, they confronted me in a violent and humiliating manner. And they dragged me, hit me repeatedly and pulled out of at my clothes in an attempt to disgrace and intimidate me. I was
Okay,
severely.
any case, but what happened thereafter? If
Thereafter, my lord,
registered, he was arrested immediately.
yes, my lord. No, my lord. On surrender, he was arrested on 30th. and-
Registered section is
my lord.
64 is correct.
I think the my lord, case was registered on, under section, my lord, the 64 F oblique 75 oblique 76,
64
my lord.
is
Page number, my lord,
rape,
16, my lord.
okay. 64F,
64 F, my lord.
2F, just a minute, huh?
Sixty-four F, my lord. I'll go, my lord. 64,
Oh.
64 to
F,
M, my lord.
F,
M, my lord.
M,
It is M, my lord.
where is M?
F,
Is F,
yes, my lord.
75.
64 to F, 75, 76, and 79.
75 is harassment,
Yes, ma'am.
sexual harassment.
75 is the sexual harassment,
76,
and
assault and use
76
of
is
criminal
assault
force.
or use criminal force. And the word and aggressor and the act intimidated to insult modesty of a woman.
3, 5.
Yes, ma'am. And I was arrested by the police man on surrender on 30th June,
Since June.
madam. On June,
Then how long he has? More than 90 days.
my lord. Not my lord, at this stage, more than my lord, 70 days, my lord.
70 days.
Now, my lord, during the pendency of this bail applications, my lord, the notice were issued to the my lord, the PP, prosecutor, public prosecutor, prosecutor, my lord. In the meantime, my lord, there was a call for the CD case diary, my lord. In the case diary, my lord, it was revealed that charge sheet has already been filed.
Okay, thereafter.
And thereafter, my lord. And
Now the report
investigation
has been called for.
my lord, investigation is completed, my lord.
Okay,
And
charge
during
is
the
already submitted
Yes, my lord.
on the same, under the same offense,
Same offense. No, my lord. That has been altered, my lord.
altered.
Yes, my lord.
What is the
Section
altered?
64(2), my lord, if lordship, on the last occasion, my lord, it was placed before this honorable court. Now, after, my lord, the filing of charge sheet, the investigation has in the charge, my lord, original charge from registered against the applicant, my lord, accused person.
What are the now the altered offense?
My lord, now it is altered to section 64 same to earlier it was F. Now it is M, my lord.
M.
Yes, my lord.
What is that?
If lordship had used the charge sheet copy of the
Just
photocopy
a
of the
minute.
charge sheet copy, my lord.
64M.
Second 3, my lord, serial number 3, section 64 to M oblique 75 rape same, 76 so same, and read with, my lord, section 6 of POCSO Act, my lord.
Just a minute. Wait,
Final police report submitted by the IO of the case on 13/6/2025, my lord.
Okay, repeat it.
No, my lord, one thing, my lord, this charge sheet has been filed during the pendency of this bail applications, my lord.
After filing of charge sheet, why don't you, or have you applied, moved bail application before the trial court?
Admittedly, no, my lord. Or else, my lord, the
Earlier?
earlier, my lord, on 2 occasions, my lord, bail application was applied and the
Rejected.
same was rejected, my lord. Only on the ground that, my lord, the investigation is at initial stage. Therefore, my lord, the bail application was rejected.
Now, could, after filing of charge sheet, could have moved?
No, my lord,
bail
As
application
I
before
as
trial
I pointed out, my lord, during the pendency of this, my lord, bail application, recently the investigation authority has filed charge sheet against me, my lord. Had it been directly filed before a charge sheet before the, my lord, the
Yes,
court.
so, you are for
I'm for the victim.
victim?
To be very fair, Latif, as per the document submitted by the victim, she is not a minor. As per her school living certificate,
She is not claiming minor also, it appears. It's
Yes,
not
my
under
lord. There
POCSO
was
Act.
no, my lord, the claims from the my lord, the
Hmm.
victims or other party that she is minor, my lord. It is the investigation authority who has put, my lord, in irregular way in the mechanic, my lord, the section 6 has been, my lord, incorporated.
He is asking for bail now at the moment because the case has already been charge sheeted, investigation completed, trial will proceed. He is asking for bail. You have any objection?
regarding bail, Latif, I will leave up to the stage of the court.
Okay, and what is your comment?
Even because since I have also received this affidavit just this morning, Your Lordship.
What affidavit is it?
It's filed by the victim, Your Lordship.
To show the
Bringing
age,
into the record the school living certificate, Your
Hmm?
Lordship. Bringing into record the school living certificate.
Okay,
Your
she is major.
Regarding it,
Yes, she
Okay.
seems to be a major, but then the IO in the charge sheet has.
incorporated, my lord.
Okay,
But, my lord, in the FIR also, my lord, it is clearly reflected that she is at the age of 20 years, my lord. Clearly reflected. And in her signature, everything, my lord. But how come, my lord, the investigation authority has inserted the section 6 of the POCSO Act, my lord?
section,
Section 6 of the POCSO Act, my lord.
section 6 is also there.
My lord, as per the charge sheet, my lord.
So it's,
Not
it?
initially, it was not registered under, it was not booked under, my lord, the section 6 of the POCSO, my lord. Subsequently, my lord, when the CD, my lord, in the report, that section 6 has been also found to be, my lord, incorporated. So therefore, my lord, at the be that as the
On
case
what
may be, my lord.
basis?
Your Lordship,
What basis?
I'll just apprise Your Lordship. I've
Yes.
just gone through the
Mhm.
record, Your Lordship. Your Lordship will see that this bail application was moved on 6/8/2025, Your Lordship.
Yeah,
Or for the
Subsequently, charge sheet was filed on 7/8/2025, wherein it was brought to this Lordship notice that section POCSO Act has been incorporated.
okay.
Now, I've just gone through because since the document has been placed both by the accused and the victim, Your Lordship,
Hmm.
which corroborate with each other, Your Lordship. I've gone through the record. It seems there was an ossification test done to the victim, Your Lordship. And in that ossification, her age is seems to be of 17 to 18 years.
Okay,
Now, if that the calculation of ratio is to be taken into consideration, there is, Your Lordship is well aware, there is an addition and subtraction of
Advantage.
2 years, Your Lordship. Otherwise, also, Your Lordship, to be very fair with my submission, Your Lordship, if there are school certificates available, Your Lordship,
Mhm.
Section 94 of the JJB Act clearly says, if Your Lordship take up Section 94 of the JJB Act, Your Lordship, because though the ossification test was done, since I've gone through it, there was no order from the court, board, or committee member for such ossification test, Your Lordship.
okay.
I'll just, because if the victim has not come up with such documents, I would have stood to the point of that, Your Lordship. If I may read 94, Your Lordship.
Yeah,
Where it is obvious to the committee or the board, based on the appearance of the person brought before it under any of the provision of this act, other than for the purpose of giving evidence that the person is a child, the committee or the board shall record such observations stating the age of the child as nearly as may be and proceed with the inquiry under section 14 or section 36 as the case may be, without waiting for further confirmation of the age. Second, subsection 2, section 2 says, in committee board has reasonable ground for doubts regarding whether the person brought before it is a child or not, The committee or the board, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining the date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board if available, and in absence thereof, the birth certificate given by a corporation or a municipal authority or a panchayat, and only in the absence of one and subsection 1 and 2 above, age shall be determined by the ossification test or any other latest medical test, determination test conducted on the orders of the committee or the board. Now, if I may take your lordship to the record, your lordship. Your lordship will see the order dated 4/8/2025, your lordship.
Of,
4/8/2025, your lordship.
of this court.
The record, no, the trial court record, your lordship.
Also record. Yes, this was passed by.
That was passed by the
Judicial
magistrate. Your
magistrate,
yes.
okay.
Your lordship will see that by this order dated 4/8/2025, since there was a prayer by the IO for insertion of section 6, your lordship.
Hmm.
Now, if your lordship will read the section of, your lordship will see the IO has not taken up any of the documents to determine the age, only on the basis of the statement of the mother as well of the child, that there is a contradictory age given by child, that is, she has stated 20 years, and mother state that she's 17 years, and ossification was conducted in terms to determine the age, your lordship. Now,
No,
section,
no
well,
order.
otherwise, yes, there is no order. Otherwise, also, to be very fair, your lordship, 94 clearly says, if there is a document, first clause, sub clause,
No need,
date of
not
birth,
required.
yes. If that document is not there, then sub clause 2 will work. If both these documents are not there, then
Then-
ossification will. So even otherwise, your lordship, these documents being brought by both the victims and the accused, the victim's document, which is at page number, your lordship will see at page number.
Now, supposing this, if POCSO Act doesn't attract, then in that case, then
Even in CC stage of CC, this dispute can be raised because ossification, first of all, it cannot be individually done by an investigation officer. Only that if there are documents to ascertain the age, ossification cannot be invoked. Your lordship.
but in any case, since there is a certificate,
Yes, filed by the victim herself, your lordship. I'll just leave it to your lordship.
this is filed by?
The victim herself,
Victim matter.
the mother of
Filed
the
by
victim,
victim.
the victim or the victim herself,
Malad,
the victim herself, your lordship.
be fairly,
She states to be 22 years, your lordship. There is a school living certificate at page number, your lordship.
Yes,
The date of birth given there is
it
7,
is 22, 22 plus now.
yes, 7/3/2023, and the document submitted by the accused at page number 25 from the same school. This is by the same
Same
head-
certificate.
same the victim's is school living certificate, and the document submitted by the accused is from the same school to certify that patient register reflects her date of birth as 7/3/2003.
The
I'll just take your lordship to the main petition, page number 25, your lordship,
page,
25.
of my bail application.
sorry. Yes,
Page number 25, your lordship,
Hmm.
will see that this is,
7/3.
yes,
It's same,
that is
same.
from
Same.
admission register, and even the living certificate is offset. So I'll
Madam,
just leave
even
it.
Page number 24 also, madam. Aadhaar card, madam.
Aadhaar card,
Aadhaar card also reflects
Yes.
same date of birth.
Same date, madam. Date of birth, madam.
Okay, then in any case, he is not a minor.
yes. Otherwise, since it has already been charged sheeted, that can be argued in the CC stage, your lordship.
Hmm.
Otherwise, I'll leave, with regard to the bail application, I'll leave it to your lordship discussion, because my objection was only in regard to the.
Since there was a POCSO.
Yes.
And my lord, regarding section 94, my lord, the Honorable Court of my lord, the Allahabad High Court, my lord, has my lord, clarified. And this Honorable Court has also my lord, already my lord, settled that position, my lord, regarding the age, my lord. Just for a moment, my lord, to clarify that aspect. My lord, it is not well known that well settled position now. My lord, when there is no any certificate, when there is no any documents, my lord, the investigation authority has to, my lord, follow the procedures for constitution of the board, my lord. When
Now, that part we will not enter into.
yes, my lord, yes.
So because let this,
Not required, my
we'll
lord.
leave it,
We'll
leave it
leave
to
it
the
to the
trial
trial
court.
Yes.
side.
At this stage, my lord, only my prayer is, my lord, the releasing of the accused persons, my lord. Yes, my lord, the investigation, everything has already been done, my lord. And he is in the custody for last, my lord, more than 70 days, my lord. So therefore, at this stage, my lord, my prayer will be, my lord, the accused persons may be released on bail, my lord, whatever the terms and conditions may be, my lord. I am ready to cooperate with the, my lord, trial and the eye of the case as and when required to be appear before him, my lord. My lord, for fair trial, my lord, the accused persons may be released on bail, my lord.
Heard Mr. M. Kathur. Learned counsel for the petitioner. I have also heard Jenny, learned additional PP for the state. And Mr.
lawyer.
A lawyer. Learned counsel appearing on behalf of the private respondent stroke victim. Para. By filing this application under section 483 of the BNSS 2023, the petitioner prays for release of the
Petitioner is
who is
mother of,
petitioner?
my lord, petitioner is the mother of the accused person, my lord.
Petitioner with the mother, and the petitioner,
Srimati Akom.
no, petitioner,
Accused name is, my lord, Akom Yomto Dango, my lord.
okay.
Petitioner name, my lord, mother, my lord, Akom Yajum Dango.
Srimati, petitioner who is mother of the accused,
Sri
prays
Akom
for
Yomto Dango.
release of the accused. Akom Yomto Dango. You are praying for only one accused,
Yes, ma'am.
okay, who has been arrested in connection with Itanagar PS case and the number 44 stroke 2025 under section 64 within bracket F stroke 75 stroke 76 stroke 3 within bracket 5 BNS 2023. Stop. During pendency of this bail application, the I have submitted charge sheet into the case against accused for offense under section. Where is the charge sheet?
Charge sheet copy, my lord, separate charge sheet copy.
Your
my lord.
Lordship, a charge sheet, since it was only submitted, filed during the pendency of this bail application, Your Lordship. It has not been filed.
My lord, I have the copy.
Okay, charge sheet submitted under which section?
My lord, section 60,
Same section. No, also in
No,
6,
addition of six.
two additional section, my lord. One is older and another is Boxer, my lord. Serial number 2, my lord. Serial number 2, section 64 2 M.
under section.
Earlier it was F. my lord.
64, 2, within bracket, M, 2 within, 2 also within bracket, M stroke 75, stroke 76, BNS, read with section 6 of POCSO Act. In the earlier petition, you have annexed a birth certificate,
Yes, madam. No, madam. It's certificate
oh, sorry,
and
co-living certificate. This POCSO Act, section 6 was included only after the magistrate order.
After the magistrate order, Your Lordship. Ossification was then done prior to that by the investigation officer,
Okay,
Your Lordship.
okay,
And then there was a prayer made that the age of the victim seems to be a minor, and therefore a prayer was made. Then when the trial magistrate, since he does not, the magistrate does not have the jurisdiction to under
Okay.
POCSO Act, Your
now
Lordship.
has it been committed to the?
Yes, yes.
Okay, and since the offense against the accused are exclusively triable by the special judge POCSO Act, the same has been committed to the special judge POCSO Act UPIA. Stop. Para. The Learning Council for the, just a minute. The Learning Council for the petitioner submits that the accused was, when he was arrested,
on 30th June 2025, madam.
was arrested in connection with the, accused was arrested in connection with the above PS case on 30th,
Madam.
30 June.
30 June, madam. 06.
Okay, 6/2025. And since then, he has been under the custody for more than 75 days. Stop. The Learning Council for the petitioner further submits that in the instant case, the POCSO Act doesn't attract against it, attract is the is the alleged victim is major at the time of alleged at the time of commission of the alleged offense, being born on 30/06, no, no, sir, 7/3/2023,
2003, madam.
2003.
0703 2003,
Yes.
madam.
Is it about when the alleged incident alleged to have taken place?
Madam, as per the FIR, madam, it is 07/06 2025, madam. Zero FIR was filed on.
No, no, no. Allegation, as per the allegation, when the incident took place,
Madam, it is not specifically mentioned.
okay. And he further submits that as for,
On 29, madam, 29 May 2025, madam.
okay, as per the FIR,
Based
in the FIR itself, the informant, the alleged victim stroke informant has mentioned her age as 20 years. Para. In addition to, not para, in addition to the above comma, the Learned Counsel for the petitioner brought to the notice of this court the affidavit filed by the victim annexing school living certificate and Aadhaar card wherein it shows that she was major being born on 2003. Stop now. The what other than this being the victim's minor, what is your prayer or submission with regards to the bail? Why you should be granted bail?
My first ground is investigation has been completed, madam. It's because
Okay,
it is
and the Learned Counsel for the petition
trial
submission
is yet to be commenced, madam.
since after completion of the investigation, the case has already been charged sheeted and the trial already begun.
Already begun, madam. I'm told, madam.
Okay,
this-
already begun.
Is on CC.
The accused may be released on bail. So that, in order to facilitate that the accused defend his case from outside the jail. Okay. Para. Miss Jeannie, Learned Additional PP, fairly submits that in view of the documents available, including the school living certificate and the Aadhaar card of the victim, the victim appears to be major at a time of incident, alleged incident, being born on 7/3/2003, and thus the Section 6 Act may not attract in the instant case. Moreover, as per the VG Act, the only in absence of the birth certificate and birth certificate from the school or the matriculate or equivalent certificate from the concerned examination board and the birth certificate given by the corporation or municipal, the court can direct for determination of the age of the victim by ossification test, by an ossification test. However, in the instant case, that appears not have been complied with. Okay, stop. And with regards to the bail prayer, she fairly submitted that since the case has already been submitted into charge, the trial already begun, she leave it at the discretion of the court. Stop. Mr. Lawyer, so you also same submission made a similar submission. Para, learning council for the parties. Also, there is the record. Stuff. It was produced before the court. Stuff. Since that, I'll pass the order, final order, with certain condition. Condition I'll give. Okay.
Well,
And then we need to complete the,
well,
they will try to complete. Okay.
Keep it.
The
Leave the-
operation portion will be some condition.
Well.
With some condition. Okay.
Item number 9,
My lord, I am for the petitioner, my lord.
Yeah. Yes. Yes.
My lord, my lord, we have got one summon, my lord, which we have replied. This is the latest in addition to this, my lord. On 24th, we are going, my client will be appearing before the GST officer, my lord, office, my lord. For that, we have submitted that. The client has already went on 1st September 2025, my lord. And I think if the GST Learned Council is there,
This
they
is,
might be aware of this.
What is it?
Lordship, this is status, Lordship.
He is
My lord, would I refresh my lord's
interim order,
memory,
any
my lord?
interim order? Any
My lord,
interim order?
Interim order in other application, my lord, in the same FIR, my lord. Other petition, other persons, my lord, other accused. My lord, their criminal petition number 6 of 2025, my
What is
lord.
this? Tanika, what is this?
Lordship, this is the
Status,
status report, yes, Lordship. Yesterday I.
no, just
submitted this,
just clarify.
case
Is there
study.
any interim order here?
No, no, Lordship,
Okay.
no interim.
This is AB.
Yes, Lordship.
Yes, my lord.
But this is the ground of rejection for the AB Lordship. This
Hmm?
is the ground for rejection Lordship. That they have furnished today Lordship, the status, latest status Lordship.
What is the material against the accused?
Lordship,
May I be permitted to address, my lord?
What is this?
Lordship, this is the Lordship, little brief about the accused person, or this applicant person Lordship.
Hmm?
This is the little detail Lordship, because this Lordship, this Faiz Ahmed, he was Lordship, already Lordship summoned before the, summoned to appear before the Lordship, concerned department Lordship, for the statement, but there also he failed to appear. This, this is Lordship, I have collected from the Lordship, GST Standing Council. Today he is unable to attend, so on behalf of submitting this Lordship.
My lord, then,
There
my
is a
lord, if
standing
that is,
council. There is a standing council.
Yes, Lordship. Yesterday, day before yesterday, he appeared, Lordship. But today, some personal difficulties, Lordship, he could not appear.
Just a minute, huh?
may I be
It is
permitted
the
to
court
submit,
need
my
to- Have you gone through
Yes, Lordship.
the report?
Yes, Lordship.
What is the material against the accused?
Lordship, material Lordship is that Lordship, there is some CDR report as well as bank transaction Lordship. It appears that Lordship that this present Lordship applicant is in the some connection with the Lordship, the main accused. The main accused Lordship, although he main accused were released on bail on the month of April 25 Lordship. Just
The main
before
accused
default-
was already released.
on default Lordship, because charge sheet could not file Lordship on time.
No,
Just
he was arrested.
he was arrested Lordship.
Okay.
And Lordship, this is the Lordship, this is also the accused Lordship, one of the accused, but Lordship, he was not complying with the notices.
What is
and
his role? Lordship, there is main accused, but what is the role?
Lordship,
of the
he
present
also involved, Lordship, because his bank account, Lordship, transaction, CGI report, everything is against him. So he
accused?
need
That-
to,
that
yes,
means
Lordship.
he is also main accused.
Yes, Lordship, he's a kind of main accused, Lordship. And Lordship, that's why, Lordship, I have called for the present status, Lordship, then I have perused your Lordship before your Lordship, the ground for rejection also.
You should have marked the relevant portion. He never appeared.
No, Lordship, and he never
My lord,
appeared.
my lord,
Because,
my
Lordship,
advocate has
only
appeared, my
money-
lord. My
only, Lordship,
advocate has
Kolkata,
appeared,
he
my lord. We have appeared on 1st September 2025, my lord. This September, my lord. And again, we have got a date to appear on Tuesday, 24th, my lord. We are again
Where is
going,
the-
my lord.
Where is the record that you
My lord,
appeared?
that I have already sent through mail. If my lord permit, my lord, again I will do the remail. Again I will mail, my lord. If I will have the learned counsel's number also, my lord, then I will produce the soft copy, my lord. This
There
is
is
the
no
stamp,
record
my
of
lord,
his
which I have
appearance
got, my
before the
lord.
police.
No, Lordship.
Just a minute.
He, Lordship, only appeared before the Lordship, Manikana Lordship and the Kolkata Lordship.
My lord, that what
On
we
the,
have got the
the
notice, my lord. We have appeared, my
notice
lord.
served, excuse me, please. Notice he's been served to him to appear before the Manikana Lordship. PS.
Okay.
He appeared there. Again, their Lordship, a few about this police Lordship, they have personal police personnel. They appeared there too, and they asked him to appear again before the Itanagar PS for the appearance to give
Why?
a
He
statement.
has already appeared before.
Lordship,
police.
that appearance is not satisfactory, Lordship. That's why he again directed to appear before the ITA PS. But he never appeared. That was, Lordship, I have already
See.
annexed their Lordship, that notice also.
You can't cause continuous harassment, huh?
Lordship, it's
Because
a kind of
if you say
investigation only
clearly
to be
says that he
completed.
appeared there where you wanted him to appear at Kolkata.
Yes,
And if
Lordship,
he had
but
appeared-
their Lordship, he could not satisfactory, Lordship, cooperate with the investigation team.
What
That's
do you
why
mean?
he again directed to appear here,
But
Lordship.
then he appeared.
Lordship, here he did not appear, Lordship, in
Okay.
ITA PS.
Your appearance, have you annexed that?
Yes,
Hello?
my lord. Yes,
Have
my
you-
lord. That
have
I
you
have given, my
annexed
lord.
that the acknowledgement that you appeared before the police? Have you
Yes, my
annexed?
lord. That is there, my lord. That is there, my lord. My lord, I kindly come to page number 47, my lord. The statement under 185, my lord.
That Manikana Lordship, he appeared
Yes,
there.
my
We
lord.
also,
Manikala,
you are not denying, Lordship.
my learned
Page
friend is saying,
27.
my lord, 47,
Page-
47, my lord. 47. Yes, my lord.
46 is the Lordship notice, Lordship.
The
47
notice,
there is-
subsequently we complied, my lord. This is the compilation, my lord. Before this, my lord, and after this, my lord, my learned counsel has appeared before GST people,
Lordship,
my lord.
on that day,
My lord,
Lordship,
Sivaji, the
again,
person name is
one
Sivaji,
at a
my lord.
time. I can't hear. One at a time, please.
Oblige, my lord. Oblige, my lord.
Just a minute, huh? So, just wait.
Yes, sir.
Where is you have replied the notice also? Or
Yes, my
you
lord, we have
complied the
replied to the
notice?
note. Yes, my lord.
Notice issued by the police? Where?
Yes, my lord. A notice issued by the police, my lord. Page 47, my lord. Kindly come, my lord, then the picture will be clear, my lord. Page 47, 47. 47, 48. This is the statement, my
47.
lord, which, yes, my lord. One senior IAS officer, my lord. His name was learned Vibhu Krishnan, my lord. So, he was one IPS cadre officer, my lord. He came, he took my statement, my lord. I gave, my lord. After that, no notices has been served from this police station again. Then GST was
Lordship-
sending me notices. So I appeared before the GST, my lord. Then again on 1st September, my lord, kindly note this date, my lord.
Where is the record that, just a minute, where is the record that you appeared before the GST?
My lord, this is not annexed over here, my lord. That my counsel has went over there, my lord. Sivaji, my lord. That annexer, if my lord wants, my lord, I will present everything, my lord.
See the page 47. Kindly see page
Yes, sir.
47. Page 47, it appears that the statement of the accused.
Lordship, that is their Lordship. In my status report also, Lordship, this statement is their Lordship. But
Okay.
this statement before the Manakana Lordship, PS. That is Kolkata, not here, Lordship. And on that day, Lordship, on the same date, Lordship, he was also Second, now notice was given to him to appear before the ITA-PS. That
Where
was
is
on
that
the
notice,
month of,
my lord?
in the month of January, Lordship. Now on the appear,
My lord,
Lordship.
When
I have
you
complied, my lord.
want this accused to appear before the IO?
Lordship,
My lord, 24,
here,
my lord.
Lordship,
24 is
he
the date
never
given to
appeared,
us, my
Lordship.
lord.
Just a minute,
Excuse me.
Mr.
Here, Lordship, in the
Obliged, ma'am.
ITA-PS, he never appeared. He appeared before the
Whether you called
ITA-PS.
for him,
Yes, Lordship, they have noticed there.
Where?
This status report, Lordship, in the next page, Lordship. Not Lordship, as per the report, Lordship, such a report, it is there, Lordship, that he again asked to serve notice to appear before the ITA-PS. That is the month of January, Lordship.
you
Now,
appear,
today,
you appear.
September, Lordship. He never appeared.
Hard, Mr.
My lord, this is the completely, my lord. My lord, on 24th, again, we are going, my lord. We have got a summon. We are going on 24th, my lord.
Hello, you
On
are
Tu-
Mr.
My lord, APZL Afzal Ansari. Yes, my lord. My lord, my lord, already the main accuse has been granted, my lord, my lord. My lord, nothing is there, my lord. Till now, the investigation is going, my lord. I am cooperating, my lord. On 24th, again, I am going, my lord. Please protect me to that extent, my lord. On 24th, I will go before the GST, my lord. Officer at Narlang, my lord. Narlang office, I am appearing over there, my lord. And on 24th, again, I am going, my lord. I have already booked my ticket, my lord. My lord, if my lord kindly go to the mail, my lord, on 14th, I have sent one mail to my lord's court, my lord. There I have annexed this document which I have
Okay.
appeared on 1st September.
Please don't disturb now. Hage,
Obliged, my lord.
Lana additional PP, appearing on behalf of Mr. T. Kipa. Lana PP, he is PP,
Lordship, I am,
Kipa is PP,
he is the standing counsel, Lordship, GST.
standing counsel.
GST. On behalf of this, I have submitted this, Lordship, on behalf of him.
On behalf of him.
Yes, Lordship. Not case study, I am submitting on behalf of state, Lordship, but
Okay,
this
okay.
is
So additional
report.
PP.
I have submitted. Yes, Lordship.
Fair. The Itanagar Police Station case number 182/24 under section 120B the petitioner Faiz Ahmed filed this application under section 438. No. 482 of the BNSS seeking pre based on the first FIR lodged by one Saurabh Kumar Pandey, Inspector Anti-Evasion, CGST, and CX Itanagar against one Rakesh Sharma. Is the main accused.
My lord, that Rakesh Sharma is already died, my lord. Somebody has forged his document, my lord. That they are not bringing into picture, my lord.
So who is the main accused?
My lord, this is Asutosh Kumar Jha, who was my accountant, chartered accountant, my lord. And earlier Ashish Kumar Jha, who died in the road accident, my lord.
Ashutosh
Main,
Kumar
The
main,
Jha.
CDR
main
record
allegation
which
is against whom?
Asutosh
Main
Kumar Jha, my
allegation
lord.
is against whom?
Asutosh Kumar Jha, Rakesh Sharma, and Rajesh Sharma. As per the complaint, my lord. The complaint is annexed, my lord, over here. It is page number 34 of my petition.
Kumar. How many accused are there?
My lord, 3, my lord. As per the FIR, my lord, 3. One is the
Namely?
company's name is in the first para, my lord, Rakesh Sharma.
Rakesh Sharma is no longer.
Yes, my lord. He is died, my lord. Somebody has used his fictitious voter
Okay,
and
there's
Aadhaar
Rakesh
card.
Sharma, Rajesh,
And
Rakesh Sharma,
then
Rajesh
Rajesh
Sharma,
Sharma.
and you are?
Asutosh Kumar
And you
Jha.
are?
My lord, I am Faiz,
You are
my lord. My
Asutosh
name is not nowhere in the FIR, my lord.
Sharma.
Asutosh Kumar Jha is in the FIR.
Okay.
And one company,
Okay.
Siddhi Vinayak.
Which company against
Siddhi
against
Vinayak
this?
Trade Merchant.
Siddhi Vinayak Trade Merchant.
If my lords kindly come to page number 34, my lord, everything I am reading from there, my lord.
Page?
34. 34.
Yes.
My lord, complaint lodged on 3/10/24. And they used to run a chartered firm, my lord. I am one of the person who is used to file the GST and everything, my lord. Everything is documented, my lord.
Okay. Rakesh Sharma and Rajesh Sharma alleging that.
Yes. Asutosh Kumar Jha, my lord, another one.
Okay.
Yes,
Then,
my lord. He
sorry,
is my
Rakesh
main chartered
Sharma,
accountant.
Rajesh Sharma, and Ashutosh Kumar. Where do we find his name?
My lord, in the 34, my lord, in the last paragraph, kindly come, my lord. Kindly come to the last paragraph, my lord. There is one notary seal, my lord, just Asutosh Kumar Jha, 4th line. From the last para, 4th line. It starts with held with HDFC Bank Kasipur branch, Kolkata by a person named Sri Asutosh Kumar Jha.
Okay, Ashutosh Kumar.
Jha. His phone number is also given, my lord.
Ashutosh Kumar Jha.
Yes, my lord.
What is the allegation against them?
My lord, they used to run chartered firm, my lord. Now they used to manipulate many firms. And that's how they used to input tax credit they used to do, my lord, in the GST filing, my lord. I was one of the client to them, my lord. I also used to get my filing done through them only. And that's how my CDR record will be there, my lord. What is new in this? They are my chartered accountant. They are running a firm.
They have cheated the government exchequer
Yes, my lord.
by passing fake IPC and the
Fake bank account, fake company. The company name is Siddhi Vinayak Trade Merchant. It is also in the same page. First, number 1, my lord. Kindly come.
they
Number
ran
1.
a fake farm. And cheated the government exchequer in tune of crores by passing fake ITC by using forged stuff. Huh? The council, no, it is submitted that the accused applicant is not the name FIR. And he is only, according
My
to
lord,
you,
I am a client of this Asutosh and Ashish Kumar Jha who died.
he
He
is
was the
only,
original
he is
chartered
only,
accountant.
he is only the client of the accused,
This-
Asutosh
Ye-
Kumar Jha.
Yes, my lord. And my GST and tax return was filed by them.
The Itanagar police has issued notice for his appearance under section 35(3) of BNSS on 3/10/2024, and accordingly he and directed him to appear before the Maniklata police station on 14/1/2025.
Which I have appeared, my lord. Annexure P2, my lord. Page number 49, the date and signature, which is showing the same date, my lord. And it is a statement under 185 BNSS.
Hmm?
My lord, it is a statement
Who
under
has-
BNSS
IPS
185.
officer
My lord, officer was that Vibhu Krishnan,
recorded
He
his
was an
statement under 185
BNSS.
BNSS by one
Vibhu Krishnan, IPS cadre. He was a person who came for
IPS
investigation.
cadre. Huh?
Yes, my lord. And I gave this statement
The
before
Lanang
him.
Council. The Lanang Council.
And this statement was, my lord, video recorded also, my lord. That is also written over there, man.
The police is again calling him to appear at Itanagar. He is
My lord,
apprehending.
GST office, my lord, 24th September, my lord. We are going, my lord.
He's and directed him to appear on when
24th September, my lord. 2025, 24th September 2025, my lord. We are again going, my lord. We have appeared on 1st September 2025, my lord. Narlang GST office.
already given a statement before the IO of the case. However, since he has been summoned to appear at Itanagar, he is apprehending his arrest in connection with the
Samir
above
Kumar
case.
Saha, my lord.
Hence this petition seeking pre-arrest bail. Stop. Huh?
My lord, I am directed to appear before one Mr. Samir Kumar Saha, Assistant Commissioner, Assistant Director, Office of Commissioner, CGST and CX, Itanagar Commissionerate, Sector A, Narlang, Arunachal Pradesh.
Miss L. Hage, Lanang, additional PP. Sami state the accused, although appear at Kolkata, however, he is not cooperating with the IO of the case and appearing before the IO at Itanagar, and therefore she has an objection to the grant of interim anticipatory bail to the accused staff.
My lord, my advocate has earlier went there, my lord. His name was Sivaji. They must be having the records, my lord. In 2024 only he went. And now again
Can
we
be
are
disposed
going,
of
my lord.
now.
Lordship, if the Lordship is giving her some protection to
Yes,
appear
protection,
before,
I'm giving
then
protection.
interim only Lordship, not final. So
Not
that we have to see whether
Okay.
he's appearing or not.
Okay.
Oblige, my lord. Oblige, my lord. That I will do, my lord.
Fixed call for the case tag, scan copy of the case tag,
Updated case study, Lordship.
updated case study. Let this matter be listed on.
My lord, one more submission, my lord.
So, name is being arrested in connection with above PS case number so and so. Okay, he shall be released on interim anticipated bail on execution of a bail bond of rupees 1 lakh with to surety of like amount to the satisfaction of the eye of the case.
Oblige, my lord.
Call for. He shall not directly or indirectly influence with the witness of the case in any manner, that he shall not leave the jurisdiction of the jurisdictional court without prior permission of the jurisdictional court. Okay? Listed
Oblige, my lord.
matters. Okay.
Obliged,
My
Lordship.
lord,
It
protection,
may be
interim
listed
protection is there.
Again on 23rd, Lordship, 23rd.
23rd.
Yes, Lordship.
Okay.
Obliged, Lordship.
23rd of
rest
this
is
month, my lord.
Yes. Right.
Item number 10.
May I please, Lordship?
Hmm.
Lordship, by virtue of interim protection from this honorable court, I have appeared before the IO on 8th of September, and I have executed the bail bond, and my statement has been recorded.
Okay.
And still now, I am under treatment because I have been beaten up by the complainant. That the gross effort, be the one who have given a first effort, and secondly, the complainant they have given. And that second effort, we have moved anticipatory bail before this honorable. And last occasion, interim protection was there. And I heard that against them also case was registered, and all the accused from the Honorable Learned District and Session Court 0, they all have granted the anticipatory bail, and now their bail has been regularized.
Okay.
Now, my lord,
Yes.
before going into the merit of the case, your lordship, I would like to apprise this honorable court that your lordship, the honorable Supreme Court has held that the High Court should, the honorable apex court has discouraged the High Court from directly entertaining the anticipatory bail.
Mhm.
We come on the main merit of the case, ma'am.
Yes.
Recently, your lordship, in 8/9/2025,
Mhm.
para 6, my lord, from 6 onward, madam. Because your lordship, this anticipatory bail is directly filed before this honorable court, madam.
Yes.
From 6, madam.
Yes.
May I read, my lord?
Yes, please.
We find that in this case, the petitioners had approached the High Court directly for pre-arrest bail under Section 482 of Bharatiya Nagrik Suraksha Sanhita 2023 for short BNSS without first approaching the Session Court for the said relief. We are of the opinion that though the concurrent jurisdiction is conferred upon the Session Court and the High Court to entertain a pre-arrest bail under Section 482 of BNSS, formerly Section 438 CRPC, the hierarchy of court demand that no person seeking such remedy should be encouraged or allowed to directly approach the High Court for exercising jurisdiction under Section 482 of BNSS, formerly Section so-and-so, by bypassing the jurisdiction of the concerned Session Court. 7. The Session Judge exercise power under Section 438 CRPC in relation to all cases registered with the police station in the particular district. This area-wise distribution of work would make it much more convenient and facilitate expeditious disposal if the application for pre-arrest bail is first filed before the session court, which would have a direct and first-hand assistance of the concerned public appointed for that particular district. The session court would also have an immediate access to the case diary, thereby facilitating a better appreciation of the fact of the case. We further feel that if the practice of entertaining the application for pre-arrest bail directly in the High Court is encouraged and the parties concerned are not relegated to first approach the session court concerned, the High Court would be flooded with a spate of pre-arrest bail application, thereby creating a chaotic situation. We say so because if the parties are required to approach the session court concerned for seeking remedy for pre-arrest bail, there is a strong probability that significant number of applications would be allowed at the level, thereby acting as a filtration process before the process reach the High Court. It is true that in most of the states, there is a consistent practice requiring the litigant concerned to first approach the session court for seeking relief of pre-arrest bail, and only in event of denial of such relief, the litigant would be granted access to approach the High Court for seeking such relief. This is of course subject to just exceptions, and the High Court, for the reason to be recorded, may entertain an application for pre-arrest bail directly in special and extraordinary circumstances. Here, Your Lordship, there is no any extraordinary circumstances because my brother has fairly submitted. The session court has granted your absolute bail. So now, Your Lordship, this is the recently in the 8/9/2025, the Honorable Apex Court has passed this order, Your Lordship. So we all are bound by this judgment, my Lord. So all this, let them give them the liberty to approach the session court, my Lord.
It was there since then only, but then people, I don't know why people used to straight away come to before High Court. And I expect probably.
Yes, and my Lord, will see, my Lord, how many matters are listed, these connected matters. Almost 45 anticipatory bail is pending for that other important listed, my Lord,
Yes.
probably, Your Lord. 31 matter, 39 matter has been listed. All are connected, and because of that, Your Lordship, the cause list is flooded with the anticipatory bail arising out of same FIR. This is the reason, Your Lordship, the Supreme Court has discouraged the Honorable High Court from entertaining directly the anticipatory bail, my Lord. So considering, Your Lordship, this judgment, there is no any requirement to go into the merit of the case, and Your Lordship, let them give a liberty to approach the session court first, my Lord.
Lordship, in my case, I have annexed because I was referred here at Tomo River Hospital. I was here at that point of time. I was under medical treatment. Even my learned PP also said the case cited, there was an exception. In my case, that will be today. I was under medical treatment here at Nahalagan. I cannot move.
Maybe, but then you see, initially it has to be, it was already there since then only. First, you have to approach the lowest court.
Yes, my Lord.
That is the rule.
And this whole matter would not have directly come to this court. If they cannot directly pray for parity also. Because, Your Lordship, so far as merit is concerned, that among them some has blown down, Your Lordship, 4 or 5 tooth of one of the victim, my Lord. It's a grievous injury. And moreover, Your Lordship, why I am not submitting on merit? Because it will affect their bail application if they approach the session court, my Lord. If this Honorable Court, Your Lordship, in compliance of this judgment, Your Lordship, send it back to the session court. Because, Your Lordship, the parity they cannot claim at this moment because the investigation is in nascent stage, my Lord. The medical report has been, requisition has been made by the IO, my Lord. However, Your Lordship, by way of affidavit, the victim have filed the medical report where it clearly shows, my Lord, the 4 or 5 tooth has been, Your Lordship, knocked down by them, my Lord. So for that, the investigation authority has to unearth the truth, who actually has done it, my Lord. So if, Your Lordship, at this stage,
Two groups.
yes, 2 groups, Your Lordship. No doubt, Your Lordship, it's emanated from a civil dispute. But, Your Lordship, in most of the cases, even the murder and all, Your Lordship, normally committed during this land dispute only. So we cannot ignore that aspect also, simply because it's a civil in nature. We are dealing with the anticipatory bail. We are not dealing in exercise of extraordinary inherent power, my Lord. So in my humble submission, my Lord, by Your Lordship, with due regards to by relying this judgment, my Lord, the Honorable FX Court, my Lord, let them approach the session court first. If they are agreed by the session court, then let them approach this Honorable Court, my Lord.
Yes, so, what is, you are for?
Lordship, in item number from 39 separate bill application, I have filed my written objection, particularly in 112 of this AP. Kindly peruse 112.
112?
Yes, I have submitted my written objection there. by filing this written objection, there is clearly prima facie case evidence to show that the involvement of the alleged accused person, that such a grievous hurt was caused to me. And I will rely on what the learned PP has said. Let them appear the questions for.
So, 112 means item 14.
Yes, sir. In item number 14, as per a record, I have submitted my written objection.
And this written objection is not maintainable at all. If we go through the depth into the written objection, they have stated our bail application was subsequent bail application. Our bail application was not subsequent bail application. And everything has been messed up. In the border case, both party injured, Lordship. And now in the present state, we have already given my statement before the IO, and we are cooperating. And we have even executed the bail bond also on the order of this honorable court. And unless and until the terms and condition is not violated, if I could have been violated the terms and condition, then that could have been different. And we also intend to file the title suit for the main crux of the disputed.
Your Lordship, by this objection, the Lordship may be clear about this case also. How the grievous the injury was. And section 116 of clause G, it clearly defined about grievous injury under BNS.
In the board case, there is a grievous injury, and this is only the submission from the complaint side, not from the IO. And I don't know what is the update of this CD. I don't know. CD was also called.
Kindly peruse the medical documents. It's very much clear.
And this medical document,
Yes,
it comes from the complainant side, not from the IO. It is their medical prescription. In my case, clearly the IO of the case has been referred to me the medical, in my case. But their case, this document, they brought themselves, not from the IO. In my bail petition also, I have annexed the medical prescription photocopies, which they have written me.
yes, in all the cases, or whether in all the cases, the accused was appear before the eye of the case.
Lordship, let me submit. Out of 39 alleged accused applicant, we approached this honorable court, and all the 39 has been protected interim. And from there on 8 September, all we 39 we appeared before the IO of the case. Then IO of the case said that only the 13% allowed to execute the bail bond, and 13% statement has been recorded. And IO said that rest of the accused, if necessary, he will call up, and he has taken the number. And why reason IO said that? Because now I am investigating only on the basis of the video, in the video footage. Only that I have been examined. And those raised, they only on the apprehension they approached this honorable court. Therefore, the IO didn't examine us. But we have approached, we have gave the protection interim bail petition to the order to the IO of the case. And IO said, if necessary, he will call. And he has taken the number also. We have cooperated.
What your case diary says?
My lord, so far as case diary is concerned, my lord, my initial submission was, my lord, this is at nascent stage, first of all, my lord. The requisition has been made. Now we are dealing with the FIR. Although counter FIR is there, your lordship. For that, nobody is before this court. But we are on the FIR 19 of 2025, wherein there is an allegation against him. No doubt, your lordship, from the pace of the FIR, initially on that expect only the my lord has granted interim. That there only it was stated that they has been assaulted, my lord. Whether the tooth has been knocked down or not, that was not there in the FIR initially, your lordship. But now the picture is clear. There 180 statement has been recorded. The two victim has clearly stated that one victim one of the victim tooth was knocked down, my lord, and that they have bring into the record by way of affidavit, my lord. And your lordship, by way of affidavit, definitely they can file because they have a participatory right, as already held in Jagdish Singh matter, my lord. If there is only any false allegation is made by the victim by way of affidavit, then they will be answerable under appropriate provision of the law, my lord. Here, your lordship, so far as the statement is concerned, my lord, here clearly stated that one of the accused tooth has been knocked down, my lord. Now, my lord, there was a group of people. My lord, we have to remember one thing. We are dealing with the anticipatory bail, my lord. And your lordship, it has been held by the apex court that under no stretch of imagination, my lord, the anticipatory bail is a rule. And it's an exception. No, my lord. It's a judicial discretion of this court. Now, your lordship, the first judgment which I have referred before this court, my lord, the recently dealt by the apex court, my lord. Earlier, your lordship, there was no any such law. There was a contradictory finding of the apex court, even from our principal bench. The Kamta Bora case was before the apex court. But now this aspect has been clarified in this judgment, my lord. Here, my lord, the notice is issued to the High Court of Kerala, my lord, by the apex court. And now, so far as merit is concerned, they clearly stated, my lord, that group of these people come and assaulted the victim and knocked down his tooth, my lord. So now this is a privilege of pre-arrest bail. It can be extended, my lord, in a case where person has been falsely implicated, my lord. But here they admitted they are in fact admitting that there was a dispute, and they cope up from, my lord, the land dispute. But your lordship, but during that dispute, civil dispute, the criminal offense has been committed. That cannot be ignored, my lord. And at this stage, my lord, this is a privilege bail. Why the absolute protection should be granted to the accused side, my lord? Only because there is a FIR or the counter FIR, how they can be.
The record says.
Record, my lord, the statement of the victim.
Whether the IO indicated that the custodial interrogation of the accused applicant is necessary.
My lord, this is one of the aspect I would clarify, my lord. Once, my lord, even in, my lord, just for hypothetically, I'm saying, my lord, even in a rape case, my lord, once the accused is appeared, if pre-arrest bail is granted to the accused person, my lord, he will be interrogated, his medical examination, everything will be done. It doesn't mean that, your lordship, once his statement, everything has been recorded, he should be released on bail. The same in this kind of case, grievous, voluntary causing grievous hurt, my lord.
Yeah. Because there was a counter complaint.
Yes, my lord.
There was a complaint from the applicant side.
Yes, your lordship.
Probably there was more than two complaints.
Yes, my
And
lord.
one from the
Victim side and one,
victim
yes,
side.
present victim, and one from the,
1925.
yes, your lordship.
So they are seeking bail in that. And then their case, their complaint, their FIR was also registered against.
Yes, my lord.
They have obtained anticipated.
They count, my lord, my humble submission. Counter FIR will not mitigate the allegation against one of the accused.
Here in this case, the FIR was lodged by the present applicant prior to the FIR lodged by the respondent.
Yes.
Respondent means the informant. It was at 2 p.m. and then the 19 was 19.
Yes, one in 1925. Yes, your lord.
1925 was lodged or registered only after 4:30, I think.
Yes, your
4:15 or 4:30.
Yes, your lord.
So this was prior.
Yes, your lord.
So that is why this, considering that there is a complaint and counter complaint, this anticipatory bail, interim anticipatory bail was granted. So my query now is whether the IO really required that they need to be interrogated.
Why, my lord, I am saying so? Because the person who has assaulted the victim, whose tooth has been knocked down, my lord, my lord, has extended interim protection. My lord,
Not yet extended.
earlier, my lord, interim protection has been granted to them. Yes. Basing on that, my lord, it is well settled, my lord. The interpretation of cooperation is what? Then when the IO called for, then person has to appear. The cooperation interpretation is done. But again, my lord, the one more thing is there. If there is a sufficient material against you, establishing your involvement in the offense, then they have to give the explanation also, my lord. And it flow from, my lord, 313, my lord. there it says, when all the incriminating material and circumstances, even in bail, your lordship, that will follow, not strictly, but the material if is placed before you, and if cross-examination is done during the interrogation, and they refused, they give false explanation and fail to give any explanation, my lord. On that aspect, my lord, the court has to be considered that.
See, during bail, we are not going to consider that.
No, yes,
Merit of the case.
my lord will see the statement, their statement, my lord.
Yes,
Once,
why do we require the accused to be inside the custody? Why do we?
because your lordship here, so far as in FIR is concerned, my lord will see in the subject, there are 12 and others is written, my lord.
If
The
this
other
is
co-accused name,
is fleeing or jumping bail, of course, or he has jumped bail conditions, or he violated any terms and conditions of the bail.
yes, my lord, the poor jump,
He is
terms,
operating under a complaint and counter complaint. If it is one-sided only, of course, if it is cause grievous injury, or if it is a heinous crime, a different case. But here is, we cannot say you have
yes, my lord,
heinous.
yes, my, yes.
Injury may be grievous, but it's not a heinous.
my lord, if it was a regular bail, my lord, then all this consideration would come. But now this is an anticipatory bail, my lord.
Yes.
That if whether for consideration anticipatory bail, my lord, whether the prima facie case is made out or not, prima facie case is there, my lord. The nature of allegation against the accused person, my lord. And the material so basing on the material so collected as on that, why, my lord, as on that the picture is why not clear? Because it is the nation stage, my lord.
Yes, that's true.
The nation stage, that is why, your lordship, it will even difficult for us to, your lordship, direct pointing on a particular accused.
Right.
And once the anticipatory bail is made absolute, my lord, it will be difficult for the investigation agency to unearth the truth, my lord.
Now,
And my lord, one more thing, my lord, as my lord is also aware of the new law, not Supreme Court, the ground of arrest is also there, my lord. A person cannot be arrested in a mechanical way, my lord, by the police now.
Right.
So if their involvement is not there, anticipatory bail does not mean that the police will arrest the accused. This is anticipatory bail, not a regular bail, my lord.
See, here is the case where in the subsequent FIR lodged by the informant, in that case, in the first case, where FIR was lodged first by the now accused applicant, so the accused has already been released on granted anticipatory bail and also made absolute.
In other case, my lord, we don't have the record on that, my lord, whether they have it granted bail or not. It is here their submission, my lord.
Sorry, it is from a reliable sources.
My lord, on reliable source, how it can be relied upon on court, then why he is approaching direct the High Court?
Yes.
This is one more thing, my lord,
That is
because we cannot ignore the apex court judgment, my lord.
while the other could approach the session court, why you could
Therefore, I
not?
said,
Why you have
my
to
case
directly
is
come to this court?
exceptional. I have annexed the medical prescription. I was taking the treatment here.
Maybe.
There
That
is-
doesn't-
I was
no.
there in trips.
That is in respect of only one applicant, not in respect of all the applicants.
Yes, absolutely.
Lordship, in this
So then,
case,
why you could not, or why you did not, while the other applicant can approach the session court, why you could not?
since indeed,
You have to satisfy.
because most of our alleged accused person, we are here, we so you can have a resident.
Maybe.
We are also having a resident, and we are looking after the present.
So you mean to say that the UPI is very far away from Itanagar? The incident where the incident took place?
Kamle.
See?
And the jurisdiction belong Planet District and Section 0. Yes, therefore we approach this honorable court because
Zero is nearer.
Yes, this
Yes,
is true.
the incident took place there at Kamle. And you have been there.
And
You were there.
interestingly, my lord, these days you don't need to go before the court and swear the affidavit. Notary is available, my lord. That is also one aspect, my lord.
Now this is for, I think, for all the advocates not to directly come.
Yes, my lord. But my lord, for that, my lord had to retrieve this judgment of the
It was
apex court, my
already
lord.
there earlier, but then of course, today you have read out.
Yes, your
And
lord.
then this is there. Now probably the advocate will also take care of
Yes, my lord. My lord, in between, my lord, there was a variation, my lord. I have a judgment. The other pool bench High Court has held that no, since a concurrent jurisdiction, they can come. Even Supreme Court, my lord, has keep this matter pending. The Kamtapura, the Guwahati High Court Bar Association.
What we'll do is if you think that it is necessary that in your FIR, which was also registered and probably the same sections, same offense. And if you says that
Different section.
they were granted anticipatory bail and also regularized, and if you think that it was in the same fight, both party involved, they were granted, and if you are also asking for parity, that session court granting anticipatory bail and making it absolute.
Then Your Honor,
We'll see, and then
may I pray then for Monday? So till then I will collect the CTC copy.
what do you say?
But my lord,
On merit, you say, what I have seen, I have gone through, of course, I haven't gone through the
CD.
CD,
Yes.
but then as per the FIR, it appears that because the present accused applicant,
Yes, madam.
their FIR was registered first.
Yes, madam.
And in apprehending that, of course, probably this rocking tooth, probably they had apprehended that one person has been caused a grievous injury. Of
Yes.
rest, of course, they have also suffered. The person is also
Yes, Your Lordship.
medical.
Yes.
He has medical document also.
Yes, madam.
But then probably on that view only, taking into the account of that entire matter only, this bail application was, the interim was protected.
Two different victims. Lordship said one victim. There are two different.
One victim from you.
No, two victims.
Okay, two.
From me.
And one from their side also serious. So equally this, we could understand that.
Yes, my lord. My lord, and so far as my lord, the parity is concerned, I have the judgment on the parity also, my lord. For parity is not absolute, my lord.
That is also not.
The role of each accused person
Yes.
involved in an offense, and moreover, their antecedent is also to be looked into, my lord.
Yes.
If the role is distinguishable,
Yes.
the parity will not apply.
Right.
So now, my lord, the others, they have also made an FIR. They have also made an FIR. Now we have to confine with the FIR against whom they are praying for an anticipatory bail.
Yes.
And your lordship, since because of the judgment of the apex court, my lord, my only humble prayer before this honorable court is, my lord, let them approach this session court, my lord, not directly before this high court, because the session court will be in the better position, in fact, my lord.
In the case, they have appeared, and then they were arrested and also released on bail. We may have to consider at the moment. And in the case where the case diary also is also not clear, and then where the IO has not recorded their statement.
12
we may have
accused,
to send it back.
my lord, 12 accused statement has been recorded, my lord.
Okay.
And my lord has given an interim protection.
Yeah.
Now every opportunity they get before to they have to state before the IO. They have not made any exculpatory statement or incriminating statement against anyone, and definitely they won't do it, my lord, because your lordship, they have already protected by this court. And I am not saying that, your lordship, the prosecution have the different technique to find out all these things, but your lordship, it is if the investigation agency is given an open hand, my lord, they will definitely not directly arrest anyone, my lord. If the investigation authority found that someone is involved in the offense, then only they will arrest, and secondly, my lord, they will assign with the ground of arrest as well, my lord. Initially, my lord, so far as the FIR is concerned, they made up a case, prima facie case, my lord. Even I have gone through the FIR, my lord. But later on, your lordship, if new...
Just a minute. In which case they have been, they appeared and then arrested and also released subsequently?
1925, my lord.
No, we are in 1925, in seven, I have NS
No.
in my ballot.
Oh, they are valid.
Yes, 1925. But then
1725.
item number?
Not
They are against 1925, my lord. They
Yes.
are approaching this court
Yes.
for
yes.
pre-arrest bail in 1925.
What I'm saying is in 1925, who are the accused persons who have been already, who had given statement, they were arrested and also released subsequently?
Item number 10 to 22.
They are named in the FIR, my lord.
Whose
My lord,
names
will,
are in
yeah, FIR, yeah, subject, your lordship will find in the subject itself, my lord.
12%.
12%.
Item 10 to 22.
22.
Yes. And we have executed bail bond and we have all the
So this
39
is
we went.
up from 10 to 22 would be 13.
Then
My lord, the victim's accused
23.
accused name is so
Hmm?
far as CD.
Then it will be 14.
My lord, as per the CD, my lord. As per the CD, my lord. Diktub Yukar,
Just a minute. Yukar, okay. 10.
Yukar Tat.
Hmm?
THAT, YUKR, Yukar Tat.
This is different. Okay. So they are different.
Yukar Tat, my lord.
Just a minute.
Yes.
The
Diktub Yukar.
Yukar,
Yes, Yukar Tat, THAT.
not them.
Deti actually,
Tat is
YUKAR,
Tat is also
THAT.
there. Okay. Okay.
Then you will say Yukar Tesi,
Okay.
and then Yukar Takom, TAKOM.
Okay. Yes. Okay.
And you will see Bomrik Teri. Bomrik Teri.
Yes.
Yukar Tei.
Mm.
In 115 of 25 bail application.
Yes.
And my lord, Yukar Toluk. 114 of 25.
Okay.
Yukar Tem.
Yes.
Yukar Akas.
Akash. There.
Yukar Ter.
Just a minute. There also.
Yes, my lord.
Just a minute. Where is Akash? Okay. Akash is also there. Okay. Then,
Akas Ter.
Hmm.
Yukar Sanjay.
Sanjay. Yes.
And Yukar Tapin alias Doni.
Yes.
They all were arrested, they appeared, arrested, and released, madam.
One more Yukar Sibo, item 31.
That is,
All together 13. We appear.
and Yukar,
So item 31. Yukar Sibo.
13.
Yes.
13 people.
Yes.
13.
13. Out of 39, 13 bail bond executed and statement has been read.
What your report says?
my lord, and now I have received the anticipated bail order issued from Guwahati High Court in respect of the above arrested accused person, and bail to be moved by 3. So, and subsequently,
Bail bond receipt is with me. But of course, statement. Bail bond receipt is with me.
and your lordship, Sri Yukar Teji.
KG.
Yes, your lord. Teji.
Yukar Sibo.
KG,
CD जो बोल रहा है. Yukar Teji.
he was also arrested.
Yes, my lord.
That is item.
Now I received the anticipated bail order issued so and so. Bail moved by so and so. And my lord, Yukar Teji, Yukar Teri.
No, Terry is Terry.
Yes.
No item.
No, yes, arrested and released. Yukar Rebia.
Item number
Terry,
10 to
Teji. And
Teji, Yukar Teji is also there. Teji. TEJI.
Teji. That is item.
yeah. Yeah, it's equal.
or it should be Tei, my lord, Tei, wrong, wrongly written as Teji. And Teri, Teri,
There is over there.
yes, my lord. Yukar Ribia,
Here.
TEI is there.
Teri, my lord.
Okay. There is item 32. No, the some of the name which was spelled out is not here.
Yes, my lord. Madam, may I read out that portion? Now I have received anticipatory bail order issued by Guwahati High Court Itanagar bench in respect of the above arrested accused person and the bail petition moved by Sri Yukar Teji, Yukar Teri, Yukar Ribia, Yukar Bonkar, Yukar Taga for release of arrestees. Subsequently, bail petition accepted by OCPS Raga on the basis of the court anticipatory bail order. Accordingly, all the arrested accused person noted above released on bail after executing bail bond with one surety of 20,000 for each.
Okay. So now their bail has accepted. So what we can regularize their bail?
Yes, my lord, my lord, so far as my lord, this, I have objection on the, my lord, Sivo is, yes, Sivo is also, Sivo statement is also recorded. Yukar Sivo, SIVO.
Item number 31.
Yeah.
13, we have executed bail bond and we have our statement has been recorded. And
Only
the-
13.
Yes, altogether from out of 39. But practically we went there.
There is more than 13 it appears as per the series.
Yes, my lord. Then, my lord, in the case where they have been they have been arrested and released, their bail may be considered, but for remaining one, let them approach the session court, my lord.
So in view of the Supreme Court order, we approach there. Okay.
Okay, I accept the Alana TP's suggestion. Let the 13 LHX persons maybe finally make the bail absolute and rest we will approach Lanet.
Oh. Or Mr. Javier Gyati, Land Council for the petitioner. I've also heard Mr. Land Edison PP for the state. And Mr. for the informant in item 14 only. All okay for the informant. Representing the informant, staff. Apprehending his arrest in connection with the Raga PS case number 19/2025 under section 192 stroke 118 within bracket 1 stroke 3 within bracket 5 of BNS. The petitioner filed this application under section 482 of BNSS 2023 seeking pre-arrest bail. Stop. Para. By an order dated 2/9/2025, this court granted interim anticipatory bail to the accused applicant.
In 295, accused was granted anticipated in 29. Again on next 39.
Just a minute. No, this is in item 1. Okay. Granted interim anticipatory bail on the following condition. Subject to the following conditions. That the accused execute a bail bond of rupees 20,000 with one surety of like amount. Next, the applicant cooperate with the investigation and appear before the IO investigating agency officer as and when called for. 3, that the applicant shall not directly or indirectly make any inducement, threat, or promise to any threat to any person acquainted with the case. 4, that the applicant shall not leave the jurisdiction of the court without permission of the not leave the jurisdiction without prior permission of the concerned court, the jurisdictional court. Stop. Para. In compliance of the above direction, the accused applicant appear before the IO of the case on when?
8/9,
8/9/2025
8 September.
and sorry, 9/2025 and gave his statement, police statement. And have his police statement recorded, Stop. On his appearance, he was arrested by the IO investigating officer, executed bail bond, and thereafter subsequently released on bail on the strength of this court's order. This court's anticipatory interim anticipatory order. Stop. The case diary indicates.
My lord, in para 5, I have marked with green line. Those are the accused who appear, arrest and release.
Okay.
Total 13, my lord.
Yes. The case diary produced before this court indicates that the accused applicant is cooperating with the investigation of the case and their statement recorded. Stop. In view of the above, the which indicates that the further custodial interrogation of the accused is no longer required. Stop. Stop. Para. In view of the above and considering that the accused has already been arrested and subsequently released on bail and has given his statement, and also considering that the further custodial interrogation is no longer required. The interrogation of the accused applicant is no longer required, comma, this court is of the opinion that the bail, interim anticipated bail granted to the accused applicant can be made absolute. Accordingly, the interim anticipated bail granted to the accused on 2/9/2025 is hereby made regularized and made absolute with the same terms and conditions, with a further condition that the accused applicant shall continue to cooperate and appear before the eye of the case and before the trial court regularly. Okay, as and when called for. Okay, with the above, this bail application stands disposed of. So that will be in respect of
13.
item 10. Just a minute,
11.
10, 11.
12.
So those are on the same day.
Same day on 2 September.
Okay,
Sorry.
10,
Till
11,
14.
12,
Item 14.
not 13.
Not that.
Okay,
No, no. 10 to 14 item.
okay, 10, 11, 12, 13,
5%.
14, same date, huh?
Same day.
Okay, and then item 15,
And item
date will change, huh?
15, 17, 18, 19,
15, 17,
20, 21
18,
on 3rd of
19, 21. That will be different date, 3rd September.
Yes, that's September. And
Okay.
race on 5 September.
And then 22,
Race remaining till
22 and 22, 31. Just a minute. 22, is you cut
on no. Twenty-two and 23.
you cut Davam name is there. You cut Davam.
Of course, verified.
You cut Davam name is probably not there. In the iOS.
Let's go verify.
No, the 23 is not there, huh? Then 31 would be Euchre Sivo. Would be there.
Sivo is there.
The 31, huh?
Yes.
31 is when? 31's bail was granted?
5-9.
31 is 5-9.
Yes.
Okay. And just a minute. 1, 2, 3. 1, 2, 3, 4, 5. 6, 7, 8, 9, 10, 11, 12, 13. That much, I think. Euchre Sivo, up to Euchre Sivo. Yes, up to Euchre Sivo. Euchre Sivo. No, including Euchre Sivo is 13.
Oh, you can see.
I think that much. Okay. Up to Euchre Sivo. So this 13 bail application, same order, only date change. Okay. And in respect of other, so
Liberty may be given to approach if necessary.
Then
before
let
the-
them withdraw, my lord.
And-
That will be better.
Yes, I may be kindly allowed to withdraw with liberty to file. if-
because their name probably IO also could not find, and then they are
Even
not in
we-
danger.
Even we went there also IO, but IO didn't.
Okay. Okay. Yes. Mr. Javier Gyati, Lana counsel for the petitioner, at this stage want to withdraw this bail application with liberty to file afresh before the Lanark Session Court. Liberty to file fresh bail application before the Lanark Session Court. Stop. This bail application stands disposed of with liberty as prayed for.
Yes.
Okay.
Deeply obliged.
Right.
Then there is up to 47, 49. Okay.
13 accused bail has been made absolute, remaining withdrawn.
Remaining with
Yes, only 13.
item number 16. Yes.
Service not completed, POCSO matter, service not completed.
Service not completed.
Yes, madam.
You want to take fresh steps or what? Wait, waited.
My lord, we have, on my part, I have taken a step.
Okay,
the-
waited.
Yes, on our part, we steps through OC.
Now remaining part is the age to ascertain whether OCPS, concerned OCPS, he complied with this honorable court order or not. Because as per my understanding, the complainant is reside within the Doimuk PS, nearby Doimuk PS, OCPS. Then if the OCPS Doimuk is not complied with the order of the honorable court, then even if I may be allowed to take fresh step also, if the OCPS is not ready to comply, then same consequence will be.
No, why? Do like that, there is no any personal enmity.
But because of their non-cooperation, why I should suffer? Because I have been in the custody now, at the age of now, 500 days in the custody. 500 days in the custody. I'm in the custody.
What happened to the trial?
I have
What is
applied
the status of the trial?
I have applied the bail application before the Lanark trial court, but it was rejected. And in this case, my lord,
No, what is
the
the status
victim-
of the trial? Before the trial court?
uh,
Trial of the
victim examined, complainant examined, only official witness is to be examined.
Okay.
Only IO.
Please,
Out of their evidence.
PCR is there, madam.
this here,
Yes,
there is a material.
yes, your lordship.
No. If we rely on the victim statement complainant, there is no such prima facie case.
No
implement
problem.
against
But,
them.
okay.
Yes.
Only then the notice is to be given to the
Yeah, victim, yes, your
victim.
lordship.
So let us ensure that the victim is
Yes.
here. If on the next date, if nobody appears, nobody turn up and it fail, then we may have to appoint one.
Amicus, yes,
counsel,
your lord.
Yes, that direction, that specific.
Isn't it?
Yes, your lordship, but notice has, your lordship will make
Yeah,
sure,
after-
we will take status from the concerned OC, whether the service notice was served or not, my lord.
Okay. Mr. T. Thorum, Lanark Council for the petitioner is present. Mr. Theatre, learned additional PP. Submitted, although notice was forward. Where do we find respect? Okay.
Office note is there.
Okay. Step was taken upon the respondent, private respondent number. The same. The return service is still awaited. Therefore, we press for some more time to confirm the same from the
Yes, Your
concerned
Lordship.
police station.
Yes, Your Lordship. Let it be on 25th, my lord.
They are allowed. Let this matter be listed on 25,
Yes, Your Lordship.
25th.
Yes, Your Lordship.
Okay.
Obliged.
An age parade for Hakama, let this matter be listed on 25th. Okay.
Item number 51.
Yes. Anyone appearing?
State we are appearing, Your Lordship.
Okay. No one appear. And what is this case? Case of 23.
Yes, Your Lordship.
This is service. In respect of respondent number 2 is still awaited.
Await for the service report then, Your Lord.
Okay. None appears on behalf of the petitioner on call, whereas Mr. P.A.T. Learned Addition PP is present. Stop. The office note dated 16/9/25 reflect that the service in respect of respondent number 2 is still awaited. In view of the above, let this matter be decided after 2 weeks. Okay.
Item number 52.
Appears on behalf of the petitioner on call. The petitioner has not, the record details that the petitioner has not yet filed additional affidavit as prayed for. Service upon the respondent number 2 is also still awaited. In view of the above, the matter stand at the list is matter after 2 weeks.
Yes.
Mr. T. at the Learned Additional PP is the
Deeply obliged.
Item number 54.
none appears on behalf of the parties on call. Service upon the respondent number 2 still awaited. In view of the above, let this matter be listed after 2 weeks. Okay.
Item number 55.
Yes. $55. Yes, we are.
Yes, Your Lordship, I'm appearing on behalf of respondent number 2, 3, 4, and 5 here.
You're appearing for the first time.
Yes, sir.
I'm for respondent number. Petitioner.
My Lord, I'm from petitioner.
Okay, you are Mr.
Emu.
Learned counsel for the petitioner is present. Mr.
N. Melong.
N.
Nangkum.
Lordship, I'm for respondent. Learned counsel would appear on behalf of respondent number
3, 4, and 5.
2, 3, 4, and 5 by filing wakalatnama. And
I'm for respondent number 1.
And Mr.
B. Kamdak.
B. Kamdak, learned counsel for the respondent number 1 is also present. So you are appearing for the first time.
No, I'm. This is
Appeared
second.
earlier.
Yes.
Okay. Yes. Or what? Record was called for? Record received. We'll fix it for admission. Since the parties are duly represented and the records of trial court record has also been received, let this matter be listed for admission after 2 weeks. Okay?
My Lord, there is interim order. Kindly let me be continued.
continue till the next date of business. What interim order was there? Okay. Okay.
Deeply obliged.
Your Honor, I have filed my affidavit in opposition. On the 17th, Your Honor.
They are in this CRP.
Yes, Your
You have filed. Have you served copy?
Honor. Today I'm serving.
Okay, then his respondent number 2, 3, 4 would appear and file affidavit. A copy of the same has been furnished to the land council for the petitioner as well as the here for the respondent.
One.
Number 1. You have served copy to the respondent number 1 also. Okay, to the respondent number 1.
Lordship, I may also allow to file,
Okay,
Criminal
then in against his name, Mr. So and so land council for the number 1 is also present and prays for some more time to file affidavit and
affidavit in reply.
reply. You for the
affidavit-
petitioner
No, no, affidavit in opposition.
position. Okay.
Your Honor, next date maybe on 30, 31.
Okay,
Possible.
opposition, prays for some time to file affidavit. Just a minute, sir. Affidavit in opposition. The prayer allowed, no prayer is allowed. Stop. Praise prayed for, comma, let this matter be listed. When? 30 October. Okay, as prayed for, let this matter be listed on 30 October, 30th. Okay, 30th October for admission. You file your affidavit in the meantime, okay? Because it will be listed on admission column, okay?
Deeply obliged.
Yes.
Item number 56.
May your lordship.
Yeah.
Your lordship, service report for the soil is still awaited.
Sorry, I have instructed to appear on behalf.
Okay, you are appearing.
Yes,
There is only one respondent.
yes.
Yes, your lordship.
Okay. Miss
M. Sora.
M.
Sora.
Sora, Lani Council for the petitioner is present. Mr.
Ibam.
Ibam, Lani Council would appear on behalf of the sole respondent.
Yes,
You have filed Wakalatnama?
yes, I have already filed, but
Okay,
Today.
and submits that he has filed Wakalatnama today itself. He will receive the copy?
yes.
Okay. Any,
Your lordship, there is an interim.
okay, you want to file any objection?
In fact, this
Affidavit?
matter became infractuous
Matter has become infractuous.
from my side. They have basically challenged the summon issue to the non, and accordingly, this honorable court has stayed the impugn summoning order.
Yes.
Thereafter, subsequently, they have implicated the other party as necessary party in the Kaba proceeding, and Kaba has already been conducted. Your Lord.
And disposed of also.
Yes, Your Lord.
You have,
And the appeal is also pending now before the appellate customary court. Your Lord.
you have knowledge about that? Information about that?
Let this matter be
This
listed
is
after
after-
short break.
After this puja vacation.
Let his senior be appear.
Okay. Okay. On the prayer of the Lani Council for the party, let this matter be listed immediately after the puja vacation. Entering puja vacation. Okay.
Obliged.
Item number 57.
It will be for admission, huh? Yes. Puja vacation for admission. Yes.
Item number 57.
No one appears. Are you appearing? Yes, it appears. You are appearing. Yes. Yes.
May I, Your Lordship? Your Lordship, I'm appearing on behalf of M. Kato.
Hmm?
I'm appearing on behalf of M. Kato for petitioner.
Okay.
So, as per the instructions,
Speaking adjournment.
yes,
Miss
L. Keche.
appearing on behalf of Mr. M. Kato, Lani Council for the petitioner. Praise for adjournment of the matter. No one appears on behalf of the respondent also. In view of the above, let this matter, the matter stand adjourned to be listed after 2 weeks.
Much obliged, Your Lordship.
Item number 58.
Yes.
May I, Your Lordship? The report yesterday, it was part hard. It was part hard.
Part hard.
Yes. This is a RSA petition. Basically, we have gone through the original title suit dismissal and the ADJ also. The dismissal order of the appeal.
This is part hard.
Yes, part hard. Now, may I proceed, Your Lordship?
Yes, just a minute. Today we have a meeting. Meeting, no? Probably. Okay.
Basically,
Will it take long? Will it take a little longer time for you? No.
for me also only 2 points has to be discussed. Whether there is a course of action, and number 2 is if course of action is there, then whether the action should be calculated from 1977 or from 2015. Only that much has to be determined. Then the substantial question of law 1 can be determined, and then this can decide. We have gone through the orders. We have read the position, the submission inquiry report filed by the extra assistant commissioner, who is respondent number 5, and we have also gone through the judgment and decree.
What was the basic
It was with regard to land donation, 3,780 square meters of land at Tirbin Circle.
For establishment of
Yes, for PWD offices.
PWD office.
My horticultural garden where
You have donated.
yes, donated by donation letter dated 1977. And then I had
1977.
77 that we have perused last time.
Okay.
Then since there was 2 conditions, number 1 for SOP, granting of SOP license and separate allocation of separate land. There was 2 condition donation letter, which was for grant of SOP license with plot of land for shopping purposes at Tirbin itself. And number 2 was for for wanted facilities to be given in near future. 2 conditional agreement letter was signed.
What was the date of agreement?
Date of agreement was 07/03/1977.
Okay, two conditions.
Yes, 2 conditions. Number 1, SOP license with plot of land.
Okay, number 2.
Number 2, any future wanted facilities like contract work, it includes compensation also. Since my
Future?
wanted facilities be given to me.
Okay, are you sure that this agreement was executed in the year 1977?
Yes.
See, SOP license was SOP license at Tirbin in the year, way back in the year 1977. Is it possible?
They have admitted by way of filing while inquiry order was given to the EAC also. EAC is also
Who signed the this agreement on behalf of the government?
It was PIs, political interpreters.
Okay, PIs.
Yes. But they have respondent number 4, who is basically occupying that plot of land, has admitted.
Just a minute.
They have admitted
Hmm.
that I have donated the land, and accordingly, in fulfillment of serial number 2, that is wanted facilities, they had awarded me contract work. They had deposit in front of the Chief Judicial Magistrate, Civil Judge. It's in annexure number 11, page 70. Annexure 11, page 70.
What is that?
This is a deposition. So as to say, this is a that they says that as per serial number 2 of donation letter dated 07/1977, your Cop Gade has been awarded contract amounting to 3,19,000 and such, and contract work order is also annexed in 69. Meaning thereby the 1977 donation letter they admit, and basing upon which they are occupying that land. And in my title suit, I have raised two points. The number one is that they are occupying my land illegally, basing on these documents, which is not as per the Land Acquisition Act.
Okay, number 1. Type, huh? Just write. It is only point, huh? 1, lane, okay. Lane was donated by the petitioner.
Yes, petition.
This is appeal.
This is appeal, now appellant.
Donated by the appellant. You write first, serial number 1, then date 7/3/1977, huh? Colon. The was donated by the petitioner was the appellant there also. This
No,
appellant was the petitioner.
Appellant is now the son. It was donated by his father, your Cop Gade, who was the
The lane in question was donated by the father of the appellant.
yes.
Petitioner was the father himself.
Yes, father himself. And during the pendency of this case, he died, he expired.
During the first appeal, I think.
During the first and second
Okay.
appeal,
Okay. Father of the appellant,
yes.
who was the petitioner in the trial court,
And also in the
and
second.
also the
Yes.
appellant in the
Yes,
in the first appellate court.
yes.
Stop. Number 2, the condition in the agreement. There were 2 conditions in the agreement. In the donation, this is what do we call agreement or what?
Yes, this is donation, conditional agreement, Your Lordship.
Okay. The donation of the horticultural garden of the petitioner, appellant's, stroke appellant's father was embedded 2 conditions. Number 1, a shop license with a plot of land for shopping purpose be immediately sanctioned. Number 2, in future, any wanted facilities be given to the land donor, landowner. Oh, okay. Then thereafter, what happened? You said
Thereafter, Your Honor, if we are going by serially, there is a Parauna, which is in annexure number 4, page 32.
what is that?
Parauna, this is Parauna issued by the Circle Officer Turbin. Here, a type copy is in page number 33. This was with regard to for submission of laws of horticultural plants and trees. the circle officer has issued that they have loss of valuations of bills submitted by the appellant's father. So he
What
was
bill?
asked to resubmit
What bill?
bill for losses of that is in page number 5, annexure 34. These are the bamboos horticultural.
This was when this was done?
This was basing on this Parona issued, it was submitted. This is of 1982. 1982.
No, Parwana is the notice only, summon only, but then what is this?
Yes, this says that Toko leaves and other horticulture bill which was
No,
submitted
what
by.
do we call this? Parwana?
Yes, Parawana. It's in the top, Your Lordship. P-O-R-O-W-A-N-A, Parawana. This is to suffice that the 1977 documents is valid, Your Lordship. I have annexed this.
This is what for this was to be submitted?
This was submitted because the land was fulfilling the condition number 2, future wanted facilities. That is 3,780 square meter was.
Where do we find that land measurement?
Land measurement is in.
It is not in the donation agreement.
That was the issue that I raised in title suit. I said that you are illegally occupying my land. And without going into the merit of the case, my case title suit
No,
was
where is the land measurement you have? in the agreement?
page 28.
What is that, page 28?
This is map of the land under the occupation of respondents. $3,780.
So according to you, entire land was donated by you?
Yes.
When this map was prepared?
This map was prepared
Sketch map para, huh? Give para number, huh? Sketch map of the donated land was prepared in the year when?
Your Lordship, that is not there. However,
the total, what is the total land?
3,780 square meter.
Donated land consists of 3,780 square meter. See, this doesn't tally with the agreement dated. The language of the agreement also doesn't tally with the date. And then the map also doesn't tally with the land. This was prepared recently. And then the agreement also prepared recently, because there cannot be this condition at in the year 1977.
The person
See,
who
we're hearing the case which, see, prima facie it appears
yes,
it's a false case, but still we get.
No, Your Lordship.
This is difficult.
Your Lordship, this land, the person who has written this agreement also, he has also defaulted it. He was PW 3.
Why he had to agree with?
Now,
He had no reason to agree with.
They,
but then you see, you have created and this made agreement. There is no date also. Is map.
All those should have been determined at the trial court itself. the dependent respondent never appeared, Your Lord. I am saying that 3,700 square meter where you have set up your office.
The trial court decided in whose favor?
Ex parte,
Ex parte against?
against me.
Against you. So
I was,
although you were not, okay, ex parte against you.
yes, respondent,
Right.
they received someone, but they did not contest. All this, whether the,
But ex parte against you means proceeding ex parte against whom?
against the respondent.
Okay. Although the government was not present,
Yes,
not contest also. Although you were the only person who were
Yes.
present, still then the case was decided against you. This indicates why you are coming again and again.
No, Your Lordship,
Huh.
they have said that there is.
Still you are you have a hope.
Yes,
that
I
you
have a
win.
It is truth that my land has been
See,
taken by
the
them.
document from here
But
itself, it
that-
is
that-
apparently it is
That
clear.
at least opportunity for proper hearing at the trial stage should have been
No,
given.
even if, see, it was you who have been heard.
Yes.
After hearing you only, it was decided against you. See,
No, there
never
is
heard the government. It should have been the government.
a document which says that they are occupying my land. They are agreeing to that 1977. There is deposition filed by themselves.
That was appreciated.
Yes.
After considering that also, after considering that only, it was decided against you.
Yeah, that's why I am here, Your Lordship. I said that there has been the erroneous application of law.
That is
Judicial
why I'm
man-
saying, that is
Yes.
why I'm saying, although you were present,
Yes.
your argument, your evidence, everything was appreciated, considered.
Yes.
And then it was only you, one-sided argument only, one-sided pleaded only, one-sided case only.
Yes.
But then still it was decided against you. Now you could understand, you should understand what status of your case.
No, I have a, means, Your Lordship, I am saying that it was erroneous.
And then the appeal also upheld the decision.
Appeal also
First
never
appeal.
appreciated the documents that they have filed, Your Lordship. Actually, they also have, what do we understand by this?
See, if there is no case, repeated filing of the case doesn't change the status of the case.
Yes.
Or cannot change the merit of the case.
Yes.
That is, see, and then sometimes the advocate should also realize.
Yes.
And then give a good advice to client whether there is a case or no. If there is no case, no need to suggest to proceed with.
Your Lordship, I was not allowed, at least they should have come up with a
It
written.
was only you, what I'm saying. You
Yes.
have heard me.
Yes.
It was only you who were all alone arguing.
Yes.
It was only you who were all alone producing the documents, evidence. It was all alone, you and you only who have been heard. You took all the time.
Yes.
But
Now,
thereafter also, the court decided, two courts,
yes.
not the trial court, but the appellate court also decided against you.
Yes.
Is this not sufficient?
No, there are some erroneous
I could also see,
Yes.
straight away, I could also see that.
They are
document
saying that
itself
there is no
will
cause
not
of,
prepare itself.
my
It can't be.
title suit was dismissed, saying that there is no cause of action. There is no cause of action, and that it is barred by the Limitation Act. Section 66 says that within 12 years I can come. By 2015, they fulfill my condition number 2, which was agreement, and they have allotted me work order in the year 2015. So condition number 1 was not fulfilled. That's why I sent them legal notice. So cause of action will arise from the date when the condition of there is a condition is broken. So I want a fair trial, Your Lordship. Rightly or wrongly, let the trial court, at least thou the department, the respondent are occupying my land. Even the inquiry says the respondent number.
Your grievance now is?
Yes, for reverting back this case.
Yeah,
to the
after reverting, what is your claim?
After reverting, my claim is that the land which you are occupying is my ancestral land. You have not acquired it under the Land Acquisition Act with proper acquisition. You have duped me by letting me through this conditional agreement. Whether you agree that conditional agreement, up which right you are claiming that land or you are occupying that. That was my query at the trial court. They should clarify that if they are occupying that land based.
Now I think in the entire Arunachal Pradesh, everybody will start claiming.
Yes, Your Lordship.
Because it was never a lane of the district administration. None of the district headquarters or the circle headquarters or ADC headquarters, whatever may be.
Yes, sir.
And then now if the person start claiming that it was my lane, and then tomorrow some other may also come.
Yes, Your Lordship. It will open a Pandora box, Your Lordship.
That I agree, Your Lordship. However, that area of land filled with the horticultural garden set up by me. On good faith, I am a renowned person in my area. On good faith, I had given it to the government.
It was not because all the headquarters established in Arunachal Pradesh were given by the villagers only. All the headquarters in entire Arunachal Pradesh, because till 44 or till some 70s, 60s or something.
Yes.
So there was nothing. So only the people invited, established here, donated. And now if they start claiming, then everybody will claim again, claim it back again, to pay compensation, no right to establish.
No, they did not contest the case, Your Lordship. At least there has to be some, my land has been, is being occupied by them. Everyone knows, even there are deposition from the inquiry report of the extra assistant commissioner also said there has been losses. At least they ought to have contested the case at the title suit and said that no, since this date.
They are not contesting. They did not contest.
Yes.
And then even if, see, a person is lying dead and then you are beating.
Yes.
Again and again. And still you could not win.
There will be,
the person is already lying.
Yes.
He is already loser. Allow you to beat again and again.
Actually,
you have done whatever you wanted, but still you could not win.
Yes, because there were some the position that and the position that the respondent parties has brought up has never been appreciated, and the council at that time also had not done justice to the appellant herein, Your Lordship. That's the issue.
Could we bring those facts, new facts, to the second appellate court, Your Lordship?
So
New
no,
facts, Your
we are only substantial question of law only.
Yes. We are dealing with substantial question of law. However, we are dealing with whether the cause of action arise or not. And what does cause of action means? Cause of action means the accumulation of facts, Your Lordship. We have to peruse the facts, and thereby we can make out whether there is a cause of action or not, Your Lordship. It makes, Your Lordship, I pray that this may be reverted back, Your Lordship, only to ascertain
when this Parvana was issued.
Parvana is issued in New York. They said that they will give me compensation, and they keep on.
This is for what? This was issued to whom?
This was issued to me, to my father, Your Lordship, the donor. It says here, I have translated. Toko leaves and other horticulture bill list which was submitted by yours has been misplaced by our office. So you are directed to resubmit a copy to CO office owner before 15/10/82 onward.
This was in a different case.
No, this
bills
was
for Toko Labs. What?
No, not different labs. Yeah. 3,700 square meters of land was a horticultural garden.
Where it is mentioned? Land was donated long back.
Yes,
77.
It's reflected in the title suit decree and title suit.
No. These Toko Labs connected with some construction material. I think house construction only.
No, Your Lordship. It says there are horticultural product bill also.
See, that must be something else, not connected with,
No, your lordship, this page 34, these are the,
no, where, see, in the agreement, it was never, where is the agreement, where it says that you will be compensated for Tokupata and all?
yes, this is
Hmm?
this is a conditional agreement, your
Tokulips.
lordship.
No, no,
Any wanted facility.
just a minute.
Yes.
What is the logic you are linking with this? Because the agreement is not, agreement doesn't say that the government will pay you any compensation. And you are now claiming Toku leaves and other horticulture for the bills.
Yes, I am linking with this to substantiate a conditional agreement with the position filed by them. Page 70. They say that
No, so this cannot be paid because it has never been the condition.
in while fulfilling,
Where it says?
it's in page number 70, your lordship. This is filed by executive engineer PWD under whose occupation the land is now. They say that as per serial number.
When the initial agreement doesn't say, subsequently, if some officer in your favor issued some order, that will not help.
No, your
If
lordship.
in the initial order, if there is,
I have been given work order also, your lordship. Work order is in my name, and they admitting that this is a matter that has to be tried at the trial court level, your lordship. They have not appreciated this. At least they should have appreciated this because the question of the veracity of that 1977 donation letter is being answered by themselves only. They are admitting. So no question of whether 1977 is valid or not. This because they themselves.
because if in the condition, it is not, if it is not a part of condition,
Yes.
then this cannot be. See, there is no logic. How do we link?
They are saying, your lordship, that too before the landed chief judicial magistrate, civil senior division, they are saying as per serial number 2 of donation letter dated such and such has been awarded contract work as and when carried out within the donated land.
Parwana was issued on
1982.
1982.
Yes.
Date?
That is 15/10/1982.
Where do we find that?
That is in page number, annexure number 14, page 32. In the last portion.
15?
Page 32, 15/10/82.
I did not see the date.
Yeah, it's just about
15/10/82. Okay.
Yes.
Parwana was issued on 15/10/82. For what?
For submission of loss of uprooting of
For submission of loss of
horticultural garden.
horticulture garden of the petitioner before the circle officer Turbin. Then thereafter, that will be the earlier one would be page 31. Page 31.
Page 31.
Page
30 and 31.
Right page also at the last. And then the Parvana would be page 30.
2 and 33, type copy.
And then what next?
Then thereafter, page 34, annexure 5. This is the, while complying their Parvana, I have submitted this.
Bill submitted before.
Yes, these are the losses. Horticultural losses.
Loss of property. Stroke bill submitted before whom?
Before circle officer.
Before circle officer.
Turbin.
Circle officer Turbin
on your lordship. This must be. Some portion might be in the trial court record, your lordship. I am unable to ascertain that.
Page 34,
Yes.
And thereafter?
Thereafter, page annexure number 6, page 36.
What is that?
This is the work order issued to me.
Okay. Pursuant to the agreement number 2 from the Circle, so the circle officer in charge, assistant engineer. Okay, the petitioner was issued work order. Your father or you?
My father,
Okay,
your
the petitioner stroke landowner was issued work order. Page 36, huh?
yes. Then thereafter,
You have executed the work also.
yes, I have
You
executed
got the
work.
bill also.
Yes, your
Okay,
lordship, with this annexure number 9 may be added serially.
What is that annex?
Annexure number 9, this is page 70.
What is that?
That is the deposition filed by the respondent number 4 PWD Basar, saying that basing on serial number 2 of donation letter, he has awarded me that contract work.
Okay. The
Page 70, annexure
page
9.
70. Okay. Okay. The work order was issued based on the agreement dated 3/7/1977. Number 2, page 70. Okay.
Yes. Thereafter, your lordship, there is a inquiry report, page 38.
Why inquiry? It was to be inquired. Who
Uh,
directed for inquiry?
To ascertain the veracity of that 1977 and
Who directed for inquiry?
CGM.
Where is the order? Where is the order?
Third, order must be in the trial court record, your lordship, but however, they have submitted it, page 38.
Next para. Based on the order of the Chief Judicial Magistrate, order dated 3/2/2017, the Extra Assistant Commissioner, EAC Turbin, submitted inquiry report
Yes,
on 22/3/2017,
yes.
page 38 to 38 to
38 to 41.
41.
Yes.
Then what happened?
And then thereafter, I send a legal notice, your lordship. It's in page number 73.
Next para. Thereafter, the petitioner issued legal notice upon whom?
Upon all the respondent, your lordship.
Upon the
Basically to
respondent
secretary
respondent government. For what?
for fulfilling of the condition, that is for grant of compensation.
Seeking fulfillment of the condition of the land donation agreement
Yes.
dated 3/7/1977. For what fulfillment?
For grant of compensation for the loss
For
of
grant
valuation,
compensation for
loss of
loss
horticultural
of,
fruits
loss
and
of horticulture garden of the petitioner. Okay, then
and also for,
that is page
this is page 73,
page
your
73.
lordship.
Okay. Then
Then thereafter, subsequent reminder, your lordship. It's in page number 78.
subsequent reminder was issued.
Yes. This is on
Page 78.
23/12/16. It was issued
Reminder issued on 23/12/16.
16. And the purse was on 6/10/2015.
Okay. The first one,
6/10/15.
6/10/2015. No, we have a meeting
Yes.
for. Then next.
Then thereafter, no compensation was given to me, and there was a broken condition of the conditional agreement, your lordship. Then I filed the title suit.
Since the next para, since the respondent did not fulfill the condition, the land donation condition dated 3/7/1977, the petitioner filed title suit before the Chief Judicial Magistrate, Alo,
Yes,
in being number where?
it's the number 20/2016.
20 of 2016.
Yes.
Within bracket, Yorkop Gadi versus the Secretary of Government, the Public Work Department, Government of Arunachal Pradesh.
Page number 42.
Okay, page 42. Okay, the case was dismissed.
Yes. Thereafter, I appealed before the
The case was dismissed. Stop. Para, next. Thereafter, the petitioner filed title appeal number 68 of 2015 before the Court of Additional District Judge Western John Basar.
yes.
The respondent did not contest the title suit and the title appeal.
Yes.
Stop. The title appeal was also dismissed by upholding and upheld the
Yes.
decision of the
Affirmed.
and affirmed the decision of the Chief Judicial Magistrate, Civil Judge, Senior Division. On which date it was passed?
It was passed on
23.
18/04/2017.
27/11/2017. 27/11. Huh? Okay. Then
Then I am before your lordship.
thereafter, the petitioner filed this second appeal. The second appeal was admitted on the following substantial question of law. Where is the substantial question of law?
Substantial question of law is in. It was formulated in by order dated 08/01/2024. 2024. 8 January 2024.
Substantial question of law. 1. Whether the title suit filed by the plaintiff stroke appellant is barred by the limitation of law, estoppel, stroke waiver. Number 2. Whether the plaintiff appellant is entitled for compensation of the horticulture on the land which has been donated free of cost under the law. Okay. And then your submission is?
My submission is, your lordship, Limitation Act 66, section 66.
Okay, para. The petitioner, the appellant refer the Limitation Act under section 66.
Yes. Part 5.
Part 5.
Yes.
What is part 5?
It says that when the forfeiture,
Which says that when the officer,
forfeiture is incurred or condition is broken.
when the
When the condition is broken, the donor can acquire back the land, your lordship.
when the no, that is not a this
The
is not a-
possession of immovable property when plaintiff has become entitled to possession by reason of any forfeiture or
no,
breach of condition.
that is not a that is not
No, substantial question of law is that it is bare by the law of limitation. They said, I am coming after. This says that within 12 years, I can.
section
66
of
Limitation Act.
Limitation Act,
Article 66.
which says
By forfeiture is incurred or the condition is broken. Page 32.
which says 66 of the Limitation Act 1963, which read as within inverted comma, for possession of immovable property when the plaintiff has become entitled to possession by any forfeiture or
breach of contract
breach of condition
within 12 years.
within 12 years. Stop. Within it has to be within 12 years. When the forfeiture is incurred or the condition is broken. Okay.
In 2015, by awarding me contract work, they fulfill condition number 2. But
The Land
condition,
Council for the appellant submits that in the year 2015,
yes,
the respondent awarded
contract work
the
and
contract
fulfills
work to the appellant
and fulfill and
and-
in partially fulfill
and partially fulfilled the
Serial
condition
number
number 2, condition number 2 of the land donation agreement
yes, and
dated 7/3/1977.
1977. And number 1 was broken. That is for allotment of land and for grant of soft
And
license.
the condition number 1 of the land donation agreement dated 7/3/1977 has not yet been fulfilled.
Yes, broken. That's why course of action will be counted from
Therefore,
2015.
Therefore, the course of action will be counted from the date of broken of the condition.
Yes, yes. From 2015 onwards.
That is from the year 2015.
After 2 legal notice were sent, Your Lordship.
The cause of action arises
After the legal notice was
after
sent,
the,
no,
after the pleader notice was issued to the government, respondent government.
yes,
Okay.
rightly. So, of course, there is no bear from the limitation act.
And therefore, and thus, there is no bar of limitation in the instant case.
Yes.
And praise for remanding back the case to the trial court for retrial of the case.
For non-consideration of relevant
no-
evidence,
For consideration of
for non-consideration of relevant evidence, that is their deposition, their acceptance of conditional agreement, Your Lordship.
Okay. So this hearing I would will because we have a meeting. Okay. Okay. Then that is only point. Mr.
R. Rakshap.
Rakshap, Land Council for the petitioner is present. Mr. Riram. Land. Is standing counsel for the
Yes, for all the respondents.
or for all the respondents.
Yes, sir.
Is
1 to
also
5.
present. The hearing remain inconclusive. List this matter again.
When? Your Lordship, most probably.
We'll say,
Let it,
we'll finish it on 25. Okay.
yes, Your Lordship. Deeply obliged.
Lordship, sincerely apologize. Lordship, actually, I was busy in court number 2. So, Lordship, item number 52. Here, Lordship, I am for petitioner.
Okay. Land Council for the petitioner. 52.
Yes, Lordship.
What was passed? Huh? Okay, Mr. You are Mr.
Emrata.
I'm at the Land Council for the petitioner is present.
Lordship, 2 weeks time may be given to additional affidavit.
And prays for 2 weeks time to file affidavit. Prayer allowed. A prayer granted. List this matter after 2 weeks. Okay.
Deeply obliged.
Then item 58 and 59. None appears on behalf of the party. List this matter after 2 weeks. Okay. 58, 59. What's it? 58 is this one. 58. Oh, this is 58. Sorry. No. 58. This one is 58 and 59. Sorry, none appear. Okay.
Item number
Have done it. John. Okay.
59 is there.
59 is there. 59 is non appear. Okay. Okay.